Hello, everybody, and welcome to the National Libertarian Party Judicial Committee hearing for Harlos versus the LNC. Today is Saturday, December 14th, 2024. We have all 7 members of the Judicial Committee present, so I think we can get started. I want to just do one unrelated announcement before we begin, just some housekeeping business. The Judicial Committee has decided to suspend its rules 3.1, 4.1, and 6.1 under our implicit authority under Robert's Rules of Order for acceptance and consideration of all new appeals as of December 12th, 2024 until January 4th, 2025. This does not apply to today's Harlos appeal being heard today. But the Judicial Committee will thus not be acting on, responding to, or considering any petitions for appeal filed from December 12th, 2024 until January 4th, 2025. This does not affect any suspension appeals as provided for in the bylaws, and those will be addressed as needed. We're going to sign off for the holidays and come back next year. I've just been too busy lately, I guess. All right. Next thing I want to do is review the agenda. We're going to start off after the opening remarks here. We're going to do opening arguments from first the appellant, 10 minutes, and then the respondent, also 10 minutes. After that, we'll have questioning by the members of the Judicial Committee, and those will be untimed. The order of questioning, I should say, by the Judicial Committee members are first Messrs. Kinsella, Montoni, Tarnoff, Latham, myself, Seebeck, and Stratton. And one thing we're going to do different than the last hearing, instead of doing all the questions for the appellant and then all the questions for the respondent, we're just going to mix them up. Because a lot of times it just gets kind of clunky, because if you're going to ask the same question to both sides, it's just a lot easier if you just do it right up front. Once we get through all of the JC members' questions, if there are any additional questions from the JC members, we'll go through the same sequence of questions again, and we'll repeat that until the JC runs out of questions. After that, we'll have closing statements by both the appellant and the respondent, 5 minutes apiece, and it'll also throw in an additional opportunity to ask any additional questions should something come up based upon the closing statements. And that's pretty much the agenda. Let's see. I want to let you know that everybody is going to be muted, but the JC is going to be always unmuted, and the only people who will be allowed to speak will be those that I recognize. Other than that, we ask please everybody remain muted. What I'd also like to do is just introduce the members of the Judicial Committee for those who don't know. I'll start off with myself, then we'll go around the others. My name is Kent Krawchuk. I have been a registered Libertarian and a party member since 1993. I've served on the Pennsylvania Libertarian Party Judicial Committee. Geez, I've lost count, over 10 years, most of them as chair. And I'm running for governor in 2026. Let me pass it down the line. Any of the JC members can just jump in there. Very brief introduction.
I think I'm alphabetically next. I'm Stephan Kinsella. I've been a LP member for 5 or 6 years now, and an attorney in Houston.
Rob Latham, longtime Libertarian. Happy to be here.
Blake Tarnoff, member since 1990, past chair of New York, secretary of New York for about a dozen years. Also an attorney in name only, and happy to be here. Thank you.
I'm Mark Montoni. I've been a Libertarian Party member since the Clark campaign in 1980, and I've been a member ever since, been very active in the Virginia Libertarian Party, and then became active in Colorado here when we moved here in 2016.
Rob Stratton, longtime Libertarian, been on the state JC for many years and different committees there. Other than that, I think we all know each other.
Mike Seebeck, 24+ year life member, currently in Alabama.
There you go. Thank you, members of the JC, and thank you all for taking this beautiful Saturday afternoon to be here today. What I'd like to do next is identify who is speaking for the appellant and the respondent. So starting with the appellant, who should we expect to hear from?
Chair Krawchuk, most of the speaking will be done. I'm sorry if my voice is croaky, sick again. But Dr. Moulton will be doing the presenting during the opening statements, but I certainly am available for questioning.
Thank you very much. For the respondent, who will be speaking?
That will be me, Angela McArdle, Jonathan McGee, one of the other authors of the respondent's brief, Jonathan Jacobs. And if you have questions regarding the investigative committee report, you may also ask those of Mr. Malagon.
All right. Thank you very much. Looking down my list of notes, I believe that concludes my introductory remarks. Is anybody on the JC? Can you let me know if did I miss anything important?
You're good so far.
Oh man. Surprise. All right. With that, let's move into the next part, which are the opening arguments for the appellant. Mr. Molson, you have the floor for the next 10 minutes.
Thank you. I'm going to request to share my screen here. So if that could be allowed here.
Knock yourself out. I'm an easygoing guy.
Okay. All right. So this is very limited time, but I'm going to try to hit the high notes. So first of all, a bit about me. My name is Dr. Chuck Moulton. I'm been a registered Libertarian Party member since I believe 1999. I've been involved since 2003. I've known Ken since even before my LP involvement.
Right.
I'm representing the appellant, Caryn Ann Harlos. So quick summary. When I was in law school, they said, if the facts are on your side, you argue the facts. Facts aren't on your side, you argue the law. The law is not on your side, you argue public policy. Here, all three are in favor of Ms. Harlos. Under the facts, she did nothing wrong. She was doing her duty as secretary. Under the law, there's a very high bar required for a cause, gross malfeasance. That bar was not met. And the policy manual in place at the time explicitly said that harsh criticism was not a valid reason for removal. Matter of public policy, it's important that the Libertarian Party and state affiliates support the LP presidential candidate. And it's important that we avoid conflicts from officers and other LNC members. And all of that supports Ms. Harlos's side. You already really ruled on a lot of these issues with the Phillies case. The holding was a Libertarian Judicial Committee hereby vetoes and declares null and void each of the decisions that are subject of this appeal. That's from page 1 of your holding. The Tarnoff opinion said all 4 specifications, the 2 charges, and the resolutions are all null and void. For failure to allege conduct that can be reasonably characterized as rising to the standard required for prosecution. So this is essentially, in legal terms, a 12b6, failure to state a claim upon which relief may be granted. So the majority opinion is all lawyers, and it's certainly understandable that lawyers and judges look for a way to decide the case in the simplest way possible, and saying that we don't meet the bar here, you don't even need to get to anything else. In contrast, there is a concurrent opinion from Mr. Seebeck and Mr. Montoni that got into a lot more detail and looked at a lot of the facts and the specifics of the allegations and the specifications, and I think did a pretty good job at showing why all of them were invalid. I should note what is meant. In legal terms, nullity means that something can be treated as if it didn't happen. Void means that a ruling is determined to be invalid and unenforceable. And the JC said not just that the charges were void and null, but also that the motion setting up the trial was void and null. So it's as if the trial never existed. So really, this whole JC hearing should be superfluous because you already ruled on it. and I think you did a good job in your ruling. So you voided those trial motions. The LNC went on to ignore and disobey your ruling. Ms. Harlos attended the December 7th, might be December 6th, LNC meeting in Providence, Rhode Island. She was not allowed to participate in that meeting despite your ruling. The LNC specifically voted not to seat her. Mr. Maligan was appointed secretary pro tempore, acted as secretary, and they passed a bunch of motions that changed the way the secretary does business without actually consulting the secretary that is recognized by the party and this judicial committee, namely Ms. Harlos. I have some questions that I would like the JC to ask the LNC because I can't directly ask these questions. So I would suggest that one or more of you ask, did the investigatory committee discuss the demand letter sent by Ms. Harlos? And when I say demand letter, this regarded the derivative lawsuit. They tried to claim they didn't know about the derivative lawsuit at the time of the investigatory committee, but there was a demand letter before the actual lawsuit was hired. Second, did the LNC discuss the derivative suit when considering adoption of the charges on January 6th? It's important to ask these questions because we believe that this entire facade is a pretext for the fact that they did not like this derivative suit. So you can ask them about this. They'll tell you one of two things. Either they tell you that they didn't discuss the derivative suit, in which case it may be revealed later, will be revealed later that they are lying, or they'll say that they did discuss these matters, in which case you know that this whole affair is a pretext and should be thrown out on that basis. So now I'm going to get a bit into cause. Our bylaw 6.7, which is controlling, says the National Committee may for cause suspend an officer by a 2/3 vote of the entire National Committee. Question is, what is cause? I had the honor of serving in your position on the Judicial Committee in the past. I was chair of the Judicial Committee for 2 terms, and I wrote the majority opinion that sustained the removal of Ms. Harlos in 2001. But here the circumstances are very different. The accusations this time boil down to her doing her job. The other difference is between then and now, the LNC defined cause in its policy manual. Before, cause wasn't defined, and we had to figure out what it meant. They also adopted a social media policy, which stated that people can't be removed for mere harsh criticism. Or harsh criticism, however, mere criticism, however harsh. In addition, the convention overturned the JC decision, saying that it was important that a Ronar trial be included and it have a fair process. So what is cause? Cause is not whatever the LNC wants it to be. It has to be valid cause under the bylaws and the policy manual. So cause isn't specifically defined in the bylaws. In 2001, it wasn't defined in the policy manual. We looked at various definitions. The cause must be the actual reason for the removal. It can't be a pretext. They need to specify the actual reason and vote on the actual reason. Policies should also be equally applied to others. So if it said that she lacks decorum and other people lack decorum, then other people similarly situated should be treated similarly. So this is a change in, there was a policy manual adopted, I believe in 2002, 1.01.4 that says no party officer shall be subject to removal from office except for failure to perform duties of the office or gross malfeasance. There have been no allegations of failure to perform duties of the office. So the question is, was there gross malfeasance? And in fact, there wasn't. Failure to perform was never alleged in any charge or specification. This supersedes, the policy manual supersedes the Ronar. Ronar says if particular charges are not defined, then only then Ronar will be controlling. But we do define them in the policy manual. The policy manual can narrow cause. Bylaw 7.1 says the National Committee shall adopt rules of procedure for the conduct of its meetings and the carrying out of its duties and responsibilities. And this is one such rule of procedure, which limits the definition of cause. In addition, there's a policy manual passed that says, and this is a paraphrase, Criticism of LNC members, even if harsh, is not a valid reason for removal under the clear language of the policy manual. So in 2001, we defined cause as conduct injurious to the organization or its purposes. Now in 2004, we have vastly different standards. Gross malfeasance is what's required. If we had used the definition from now in the 2001 case, I would not have voted to remove her. I would not have sustained the LNC's decision, and I don't think my colleagues would have either. So what are some differences? Misconduct is a broader umbrella term, which includes not only malfeasance, but also misfeasance, nonfeasance, harassment, embezzlement, etc. The policy manual defines cause only as gross malfeasance, not misconduct. In contrast, many of the charges talk about misconduct. Malfeasance is committing an illegal or unauthorized wrongful act, which was intentional. Always involves dishonesty, illegality. Different from misfeasance or nonfeasance. Has to be gross, meaning flagrant or extreme. There were examples that were cited when this policy manual was originally passed. These charges are nothing like those examples. They cannot retroactively change this. Even though they have repealed these provisions of the policy manual, they were in place when this conduct happened. And it's important that people be given notice of what behavior they will be held to. Nothing about these charges falls in gross malfeasance. There are a lot of other problems that I can't get to because of, so the trial was held in executive session, which is a big issue. Unfortunately, they've thrown a fire hose of charges, and we didn't have very much time in the trial and don't have very much time now. Please ask as many questions as possible because I would like to get into these things in more detail. Executive session was only supposed to be used for discussion of personnel matters, contractual negotiations, etc., which was not happened for the trial. And when this bylaw was passed, we said that it should not be used for trials. Thank you very much.
And thank you, Mr. Moulton. Very persuasive. I always like listening to you, sir. All right, we shall now move on to the respondent. Ms. McCardle, you have the floor for the next 10 minutes.
Thank you. The LNC removes that Ms. Harlos' trial was carried out properly. She had a trial. She was afforded due process. Ronar 63.5 sets forth a standard for due process and a removal trial. We also believe she committed obstruction of process, tried not to have a trial, but we did have a trial. She filed a lawsuit in retaliation for the appointment of an investigative committee. The removal process started prior to her lawsuit. She filed a complaint against one of our attorneys. She filed a complaint against one of our parliamentarians. She argued that the 2022 convention precedent would not allow her removal. As a reminder, we followed a lengthy trial removal process to honor the will of the delegates in 2022, but there is no actual precedent in Ronar or our bylaws. This is not a court. The JC, with all due respect, is a JC, not a legislative body. And the convention resolution stating Ms. Harlos deserved a proper trial in 2021 was not contradicted by her actions. If precedent is going to be set, the only way to literally set that is through a bylaws change with in the Libertarian Party. The burden of proof is on her, and she has taken out much of her time, with different arguments. But she has not demonstrated that a blatant bylaws violation took place during her removal hearing. Mr. Moulton said that for cause can be controlling, and we agree. She was removed for cause for flagrant extreme acts. Her actions constitute gross malfeasance. The IC report indicated so, and that is what we all voted on. We voted in favor of the recommendations of the report. That report stated all but two, not including Ms. Harlos, expressed a desire to see the committee recommend Ms. Harlos' removal for her perceived malfeasance. The words misconduct in the initial resolution and malfeasance found in the LNC policy manual are undefined in any internal party document. I'm quoting the IC report. The IC will therefore interpret these words in a manner that gives effect to their common and ordinary meanings. Additionally, while the term malfeasance is one with multiple meanings in all instances, it refers to an act of wrongdoing, whether legally, morally, or in causing some type of harm to a person or organization. That's what we voted on, gross malfeasance. The voiding of anything from the October 6th meeting has no bearing on the outcome of her removal. Those charges were already disposed of. The JC can void them all out, and that's fine. The motion to adopt charges and the motion to convict and the motion to suspend are all completely different charges, and they were all adopted by a 2/3 majority at that trial. The policy manual does not hold the same weight as the bylaws. It is changed regularly and it can be overruled by a vote. And it has happened before and it will continue to happen in the future. The removal vote of Caryn Ann Harlos certainly met or exceeded any vote threshold to overrule the policy manual. The LNC and I believe that the charges we voted on constituted gross malfeasance and were grounds for removal, and we have all submitted amicus briefs detailing that gross malfeasance. The policy manual, however, no longer requires gross malfeasance for removal. Ms. Harlos is a threat to the stability of our organization and to any organization. We passed her removal with conviction, and it should be upheld. Mr. McGee, do you have anything to add? Got about 5 minutes.
Thank you. I think it's also very telling from the appellant's opening statement that the facts are presented amount to a circular statement that Ms. Harlos did nothing wrong. She simply did her duty. To be clear, that is not the contention of the LNC whatsoever. The issue is not with the original submission of certificate of nomination itself, but with the circumstances surrounding that submission. First, the action was not in the scope of her duties as secretary and directly violated the directive issued by the chair. The chair was elected to run the party, not the secretary, and not even the presidential nominee. Second, she knew that staff was responsible for managing and distributing certificates of nomination.
Mr. McGee,
And that it was up to the Colorado affiliate after, yes,
go ahead. Sorry.
And third, nearly a week after the most problematic resolution cited during trial, she took it upon herself to contact the Secretary of State and then unilaterally submitted the certificate of nomination after knowing that the Colorado affiliate had taken no such action. Fourth, knowing these things, Ms. Harlos had to search fairly diligently to find a certificate of nomination form that only required a signature of the secretary. And fifth, based on a July 7th tweet by Ms. Harlos, she knew that RFK Jr. had collected enough signatures to be on the ballot in Colorado as an independent. And she also knew that no other person could sign a different certificate of nomination except for the chair and the secretary. There was no evidence provided, and still has been no evidence provided, that the chair was in collusion with the Colorado affiliate to this end. In fact, to the contrary, it was the actions of the chair that initially created the window of time that allowed Ms. Harlos to unilaterally submit this certificate of nomination in violation of the specific directive. Subsequent to that, almost immediately, the Colorado affiliate started sending us letters threatening action against us, and it was obvious that Secretary Harlos's actions had in fact exposed us to legal liability. If the matter had simply been dropped there and mediation had been engaged in, that would have been that, and we all could have moved on. Instead, apparently, Ms. Harlos decided to take it personal and through a series of legal actions, punitively attempted to punish the Colorado affiliate for their hubris. And after several attempts to mediate, an IC committee was formed. So, in summary, the issue here is not that Ms. Harlos submitted the Colorado certificate of nomination. It is that after having already pursued actions to attempt to remedy the breach of the bylaws, she herself breached the bylaws by taking matters into her own hands and acting outside of the scope of her duties, knowing that there was no imminent threat to the LPCO ballot line. In taking this unnecessary action, she exposed the LNC to serious legal liability and created a hostile situation between the LNC, the Colorado affiliate, and herself. And in spite of attempts to de-escalate the situation through mediation, Ms. Harlos continued to escalate them by her actions. Finally, in response, the LNC decided to pursue an investigation of Ms. Harlos, which she interfered with and attempted to obstruct at every twist and turn.
Hazel, no.
Let's pass it to Mr. Jacobs.
Hazel, no.
Thank you.
No.
I wanted to deal with something rather specific here, which was obstruction, which was demonstrated in the report and was handled in the trial. Some of the obstruction included, well, first of all, obstruction of the process, the legislative process, would be something that would reach the level of malfeasance, and repeatedly it would reach the level of gross malfeasance. This is what came out from the report, and I'm just quoting from the report. The first thing is her claim that the convention had already ruled on the IC. They had not. The second thing was a series of tweets, not mean tweets, not tweets saying anything bad about anybody, but tweets regarding things such as this, 82524, it's on page 23 of the report, contacting state chairs. Falsely claiming that the chair had, quote, already screwed the pooch on procedural matters. That was 82724 at 816. Falsely claiming that the IC needed to know about the crimes, and that's in quotes, before investigating. That was 9/12/24, and claiming that the investigatory committee should not be involved in the trial, which would be a violation of Robert. That was at 9/15/24. Those are on pages 23 and 24 of the report. There are probably other examples that can come up. Certain actions that she has taken against the parliamentarian in the person of myself and against the legal counsel would probably constitute that as well. But they were not directly put into the report because they were happening as the report was being, well, basically between the time that the report was issued and the time of the trial. That's all the time that I have.
All right. Thank you all for your contributions. Next, we will move to questions by members of the Judicial Committee, and according to the randomization of order selected by our good buddy Grok. First to go is Mr. Kinsella.
All right, I have a question for Mr. Moulton. Dr. Moulton?
Yes, I'm here.
Okay, you said that there can't be a retroactive effect by changing the policy manual standards. I mean, a quick Google search shows that that is a due process standard for the change of criminal laws, but there seems to be discretion on the part of prosecutorial discretion. In other words, when you change the standard for charging or prosecutorial discretion, that is not an ex post facto or due process concern. I wonder if you have any thoughts on that.
I think a better analogy here is employment law rather than criminal law. So if an employee manual is updated, then basically people need to be put on notice of what's allowed and what's not allowed. And if there's clear notice that something is allowed, you can't change it after the fact to say that it wasn't allowed and punish them for that past conduct. And that's what they're doing here. If they, in fact, try to do that. We're not saying that it can't have prospective effect. So if this appeal is not sustained and then they put her on trial again for something she does in the future, then clearly the standards then would be.
Got it. One follow-up. Do you think that Mrs. Harlos filed the paperwork that she was instructed not to file because she relied upon the policy manual language?
I think she relied mostly on her duties as secretary. That's what she's supposed to do.
So she would have done it. She would have done it anyway. So the policy manual. Okay, so she didn't rely on that. I have a few questions.
I think it's still relevant. But
okay, that's fine. A few questions. I want to go through this quickly to give others time. Ms. McCardle, I have a few questions for you.
Sure.
I understand. So you're asking us to overrule our previous Phillies decision. Is that correct?
I'm not sure if that's necessary. I think, the reason that I reached out for additional questions was to clarify if you thought that ruling those things voided the trial. And in our opinion, It does not, because those charges were adopted independently.
Okay, I think I think you would agree that a trial is necessary before the vote of the LNC to suspend someone after the trial. I think you would agree to that, correct?
I'm sorry, can you rephrase that?
Would you agree that for the LNC to suspend and remove an officer, this has to follow a trial?
You mean removal or temporary suspension?
I mean suspension that leads to removal.
I don't think that a trial is necessary for temporary suspension.
No, I'm talking about permanent suspension, permanent removal.
As of the time that we had the trial, yes.
Okay.
According to our policy manual. I mean, now, if you could also make the argument that we can override the policy manual because the bylaws do not require a written or a Ronar trial. They don't require it.
Don't the bylaws invoke Roberts, which does require due process in the trial?
They do invoke Roberts, but they do not invoke Roberts for specifically regarding the removal process.
Okay, so you don't think
we erred on the side of caution, and that's why we had the trial.
Okay, so despite the 2022 resolution of the delegates or vote by the delegates, and despite the requirement for a trial in the policy manual, you think that if the policy manual did not require a trial, then the LNC has the authority to vote to remove an officer without a trial?
Yes, I do.
Okay. Do you think that the IC report is currently in evidence before us now?
Yes, it is. We sent it to you.
How was it admitted to us or submitted to us?
We submitted it to you via email.
Okay. What about before the Phillies appeal? Was it in evidence at that point in time?
Oh, I don't recall if we submitted it. I believe it was. I think we submitted it right before the hearing.
So despite the talk previously about the IC report being private and not for public consumption, you believe that the JC is entitled to review and rely upon the evidence in the IC report?
Yes, absolutely. So one of the reasons that we discussed this with our legal counsel, that Ms. Harlos has made portions of it public already. And at that point, you know, the cat is out of the bag and there are things in it that are being misrepresented and the entire truth needs to come out as opposed to things being selectively pulled out.
Okay. Just as a matter of curiosity, I noticed in your reply brief, which I think we got this morning, your amicus, you mentioned that there was a difference in terminology. The policy manual uses the term gross malfeasance, but the charge was gross misconduct. Was there any reason for that change used by?
No, I think that they were trying to just be very precise in their speech and their description of what gross malfeasance was.
Okay.
And I think some of this is also a little bit semantics, you know, like what is the best description for this word? How do we break this down and that down?
Okay. In your brief, you said that the removal of Harlos met or exceeded any vote threshold to overrule the policy manual. My question is, are you saying that the vote to suspend following trial was effectively a vote to amend the policy manual, or was it a vote to waive it? I mean, was the policy manual actually modified by that vote, even though the vote was a vote to suspend and not a vote to amend the policy manual?
I think that, sorry, that was several questions at once. I think that our vote was to remove Ms. Harlos. And in the event that someone thinks that that we didn't meet the threshold for gross malfeasance, which I contended that we did, and that is literally what we voted on, 30 pages plus of it, that the vote threshold to amend a policy manual so that we would be in compliance over a semantics disagreement is there. And that the will of the LNC was to remove her by hook or by crook. And if it would have, if we thought that we needed to amend the policy manual to allow that or to change the definition of malfeasance to suit someone else's definition of malfeasance, we would have done that. Two-thirds of the body was moving in lockstep in agreement for various reasons.
Okay, so if you contend that when the LNC voted for the suspension, they effectively waived or modified that provision of the policy manual as necessary to charge Ms. Harlos under the broader cause standard of the bylaws, Um, um, what about Dr. Moulton's ex post facto concerns that standard was not applicable at the time of the conduct under the charges?
That the standard of for cause removal was not
No,
applicable?
that the standard, the narrower standard of gross misconduct under the policy manual, if you basically waive that and say, no, we're going to rely upon the broader cause standard in the bylaws, why is that not an ex post facto or due process problem to charge her for something that we would argue could not have been charged under the policy manual, but maybe could have been charged under the bylaws at the time of the conduct?
I guess I don't understand the question. I'm sorry.
Why is it not an ex facto problem to say that you can charge her for a broader cause standard by just waiving the narrower standard under the policy manual when you voted to suspend?
I think that if we had an arbitrary or frivolous argument for removing her, that would be an issue. But that's not the argument that we made. We didn't hold a multi-hour trial over a handful of mean tweets or factionalism or disliking her. What we removed her for was a very high threshold and very damaging.
Okay, just one more quick one. I understand that the argument is that Ms. Harlos did not have the clear authority to file the paperwork. She might have had the obligation, as you did, to sign documents, but to file it is more of an administrative thing. And that your understanding is that she was instructed not to file. So she was given an instruction that she disobeyed.
True.
Was that instruction given by you as chair? Or
Yes.
was it given by the Reconciliation Committee? Was it given by you as authorized by the Reconciliation Committee? How would you characterize your authority to issue that instruction?
I mean, my authority comes straight out of the bylaws. The chair is the chief executive officer of the party with the full authority to direct its business and affairs. And the secretary shall perform such duties as assigned by the chair or the national committee. And I assign duties and I give instructions. And there has been evidence submitted, and I believe there was some in Ms. Yanuskovich's amicus brief, that it was not under her regular, it's not in the policy manual, it's not in the bylaws, it doesn't exist in any written authority that it's her job to send things straight to the Secretary of State.
Okay, thank you. I'm done.
Yep.
Ken, you're muted.
How horrible. My apologies. Thank you, Mr. Kinsella. Let's move on to the next one, which would be Mr. Montoni. The show is yours, sir.
It was said that Ms. Harlos had to do a deep, time-consuming search to find a form she could use to sign off on. I Googled into one with 4 clicks and a couple of words, basically, in less than a minute. And I'm pretty sure it's the same exact one that she ended up signing. What is the source of the contention that she had to take this deep, long dive to find that form? It's on the Secretary of State's website.
I'm sorry, is that a question for me?
I guess, yes, the respondent.
Well, I haven't Googled. I mean, I guess I'm not really sure how you want me to answer. Because
Okay,
the point is that she did something outside of the scope of her authority and, directly contravening my instructions.
Okay, I'm trying to get the background on the claim that
Mhm.
she did something that took some sort of time investment and a major effort to get to the proper form. So where did that come from?
Well, we signed forms, as she notes in her lawsuit against us. We both signed and notarized forms the day after the National Convention convened, and certificate of nomination forms, including one for Colorado. So whatever she submitted, she searched for, signed it secretly, didn't get my signature. The whole point of it was that, haha, I didn't need Angela McArdle's signature. And then she called and told on herself to Kathy Yanuskavich and tried to get Kathy in on her scheme, and then did it without my knowledge. That's how that went down. I don't know how many minutes it took her to figure it out. I wasn't there.
Okay, I just wanted to understand why this was turned into something that was supposedly hard to find.
Couldn't tell you.
But it's clear that I'm not going to get that. So the other question is, I think we all know that state laws and, well, any kind of laws trump organizational bylaws and internal agreements and everything else. Now, if a state puts a form in front of us that says the chair or the secretary may sign either one, why is your contention that only the chair has the authority to sign that form?
Oh,
State
well,
law,
no one,
state law trumps our bylaws, and it also trumps our chain of authority.
sure, but you said may, not shall. There's no mandate that it be signed on day whatever, 2.5 months prior to the deadline and
Right.
sent in, when there was a clear and obvious path towards getting it in without this trial, without all the drama, without cease and desist letters and multiple lawsuits.
All right, Mr. Chair, I'm done.
All right. Thank you very much, Mr. Montoni. Next up, Mr. Tarnoff. Yours, sir.
Hi. I only have a couple of questions for Ms. McArdle. I believe in the Phillies case hearing, you stated that you believe that Ms. Harlos' conduct was gross malfeasance. But looking at the Phillies' opinion, do you feel that she engaged in gross malfeasance in the standard that was outlined in the Phillies' opinion, as opposed to your personal opinion?
I'm sorry. Gross malfeasance. Are you talking about different acts by the secretary?
Yes. Did she engage in conduct that meets the definition of gross malfeasance as we stated in the Phillies' opinion? I can read that for you if you
Yes.
like. I think I have it right here.
Yes, I do.
It
I
says-
believe all of the acts that we voted on October 6th and again on the removal trial all constituted gross malfeasance.
Well, we ruled that those specifications did not allege conduct that met the standard of gross malfeasance. So I'm asking, are there other acts in the reflected in the investigatory report that would constitute gross malfeasance as we outlined in the Phillies' opinion, but were not alleged in the in the four specifications that were predicatory to the trial?
Okay, we voted again at the trial after also hearing evidence, and arguments from Ms. Harlos and Mr. Moulton as well. And I would say that is all, rolled into our vote. The summation of everything in the IC report up until the trial. And at the trial, we were able, to review additional evidence. We could adopt new charges and so on and so forth.
So you think that there is conduct reflected in the investigatory report that meets the definition of gross malfeasance that was detailed in the Phillies opinion.
Yes, and outside of it as well. I think that the conduct from the middle of July onward meets the threshold for gross malfeasance.
Okay, and I'm just curious. I mean, so there was worse conduct, objectively
Sure.
worse conduct
Yeah.
in the IC report than in the specifications, correct?
Sure, in the details that are described, absolutely. I mean, the specifications didn't list every particular thing that happened.
Sure, but I'm just wondering why you didn't allege, the worst of the conduct that would, that would leave no doubt as to the fact that Ms. Harlos engaged in gross malfeasance. Why did you hold back? It seems like you held back in the specifications and didn't allege the worst conduct. Why didn't you do that? And
Well,
if
I
you
think
lose
they're
today,
descriptive of the entire report. Conduct that disturbs the well-being of the Libertarian Party, hampers it in its work, and that renders her unfit for the office of secretary. There are numerous things throughout the IC report that indicate that, and there are things that I included in my amicus brief, like her perjuring herself in her latest First Amendment complaint against us. It's unfitness.
why didn't you allege those in the charges, in the specifications?
I don't believe we had an FAC by the time the IC report came out. And then obviously we're doing this delicate dance of trying to not be accused of retaliation, which is absurd on its face since she filed a lawsuit before these things came out. But, when we're under terroristic legal threats like we have been for a couple of months, we're trying to be very careful. And,
Okay,
I mean, gross
not sure
malfeasance, we feel that we've defined it. And
I'm not
we
sure if
stand by it.
I'm understanding the gist. Well, the gist, the main point of in the Phillies' opinion was that because conduct that could be considered gross malfeasance was not actually alleged in the specifications, that was the reason why the specifications were ruled null and void or out of order. So
maybe I am not articulating properly, our technical view of the matter. If Mr. Jacobs wants to, correct something that I'm saying, I mean, we've spent many hours on this.
May I?
well, that's
May I?
yes,
Thank
it's okay
you.
with me, Mr. Chair.
Go for it.
Agrees.
Thank you. First of all, basically, I will agree with you that Ms. Harlos was undercharged. I think that there were many things that she could have been charged with very specifically, but that it was covered under the panoply of the actual charges. As I noted in the opening argument, there is something that by your definition constitutes gross malfeasance. Repeatedly going out and trying to obstruct the investigation, which she has done repeatedly and which is documented in the IC report. That is one item under the broader injuring the or damaging the well-being. I'm trying to remember the direct term, hampering the well-being of the Libertarian Party. That one thing can, in fact, be gross malfeasance. It just doesn't have to be called gross malfeasance. That was demonstrated, and that is in the report. Is that helpful?
Yes, but it's not in the specifications.
I will agree that it is not a specified thing saying this is gross malfeasance, but the act of gross malfeasance in this case is covered under the I'm trying to remember the correct term, the injuring the well-being of the organization. It is a subset of that. That is a broader act, but the act is still the same. Trying to think of a good analogy. I would assume that if I hit you over the head with a tire iron, I'm obviously joking, that would be considered assault, and that might be considered assault and battery or something such as that. I could be charged for some type of maybe simple assault, even though I've done something far worse than committed simple assault. It's basically a question of her being undercharged here, but the act itself would still be assault and battery. Is that helpful?
Well, yeah. Using your analogy, if you charge the person with, if the crime was, assault with a deadly weapon, and all you charged and specified was, brandishing a tire iron, that would not be enough, right? You'd have to say it actually hit the person with the tire iron.
Well, that would be enough for a conviction.
My understanding, well, just even to allege it, right? You have to allege something that meets the element, So my understanding is that the worst conduct she engaged in wasn't alleged because you were concerned about possible litigation as a result of that for defamation. Is that why the worst conduct she engaged in was not specified?
I can't answer that. I was not part of the decision to actually to determine what the charges were.
Okay, well, I understood that's what Ms. McCardle just.
Perhaps Mr. McGee might.
I think there are things that we're just unfortunately not privy to say because it's going to be a violation of our attorney-client privilege, and that's something that the appellants pushed for us to do earlier, and we're not going to violate attorney-client privilege, and that's total lawfare and weaponization of the JC system against us in a lawsuit. But if Mr. McGee has anything else he'd like to add that is not violating attorney-client privilege, certainly he can.
Okay, well, I would say that there are probably ways to phrase the specifications and the charges that would indicate that there was at least potentially gross malfeasance. And, the Phillies opinion found that what the specifications actually said could not, even in the light most favorable to the LNC, could not be considered gross malfeasance. So I think, if I understand your reason for not alleging it, is you were concerned about litigation, but I think there's probably some way to phrase it that would give at least an indication that you're alleging that she engaged in some kind of grossly malfeasant conduct. So if you had a chance to read the IC report yet? I looked through it, okay. but you didn't. The IC report is not the specifications. The specifications themselves have to allege conduct that rises to gross malfeasance. That was what the Phillies opinion said. You have to allege the gross malfeasance.
Okay. Our position is that it's alleged through the specifications, but I understand we have a disagreement.
Okay. If you were to lose today on that basis, would you refile the charges and specifications that and allege in them the conduct that reaches the level of gross malfeasance?
Immediately, and likely we would also include that she's perjured herself in her First Amendment complaint against us and attach a copy of that along with evidence of perjury, which I believe some of you already have that. But we will certainly escalate it.
Okay.
And it, maybe perhaps, well, how much more legal liability can we assume since we've already been sued? Ugly situation for us. I guess that if our hand is going to be forced, we're going to be forced.
I don't know if perjury would rise to the level of gross malfeasance or not. It may.
That's good to know.
I would say so, but I don't know for sure. I have to think about that. But that's fine. But whatever conduct you allege, if it would rise to the level of gross malfeasance, then there wouldn't be a problem with moving the case forward to trial, I would think.
Well, I'd also point out, though, that we've changed the policy manual. The threshold is much lower now. There is no gross malfeasance threshold. But I would assume that perjury, which is a punishable crime, would reach gross malfeasance. But if not, certainly informing us of what the definition of gross malfeasance is, if we're going to be held to it, would be helpful.
Well, I had another question, but Jay made me lose my train of thought. So I guess he's going to get his wish. Thank you.
All right. Thank you, Blay. One thing I want to jump in here, those of you on the chat, hey, can you be a little nicer? Show a little decorum there. Stop calling each other names, things like that. Hey, we're all big boys here and big girls. Let's act that way. All right, next up, Rod Latham. Your question, sir.
Thank you, Mr. Chair. Gosh, I think I'll actually start where we left off on that prior exchange. So if the LNC is having an intent to, let's say this JC, decides that the removal action of November 9th was not well taken, procedurally, can the LNC apply its new standard to something that happened prior to the imposition of its standard? And if so, why? I'll direct it to Chair McCardle first, but I think I'll also want to hear from Dr. Moulton.
Do you mean, can we make a retroactive argument that since we changed the policy manual, she should still be suspended?
No, the question is, you just in response to Mr. Tarnoff's question, that the LNC would be looking to make another removal action based on statements made, I guess, in an amended complaint. My understanding is that amended complaint preceded the LNC's change of the language in the policy manual. So, and I almost hate to even go down this rabbit hole because we're talking about something in the future, but maybe it'll elucidate in some level the party's understanding of what operative standards we're dealing with in terms of the policy manual and the bylaws. So just again, so my question is, can the LNC apply an amended policy manual to conduct that occurred before the adoption of that amended language? Is my question making some sense there?
It does. I think the answer to that is yes, depending on what it was. And I would say that this situation, that's actually not even 100% relevant because the bad conduct at this point is still ongoing.
Okay, and let me kick it over to Dr. Moulton just to see if he has thoughts on that.
I would say that they cannot apply a new standard retroactively, but they could apply it prospectively. That if they tried to charge her for things she's done in the past, then it would be at the standard that was in place when the conduct happened. And if they tried to charge her with something that happens, after they amend the policy manual, then I agree in that case, they would have the lower standard.
And let me, I guess, just throw it this way. So I guess one could make the argument this pleading that contains the allegedly, false language was filed the person who made the pleading has the opportunity to withdraw that pleading or amend that pleading. Because it hasn't been withdrawn or amended, is this ongoing conduct that is now subject to this new standard? Do you see my question?
I do understand your question. And I would say that if they have adequate opportunity to change the filing, as you said, to withdraw it or amendment, then I would say yes, but it couldn't be immediately. You would have to give them time to actually take that action.
Okay. I'm gonna go.
Let me just clarify that we have not conceded that the statements that she filed were false.
Sure.
Again, we were sent this brief less than an hour before this trial, so didn't have much time to investigate and prepare a defense to these new things, which were not in the charges. But
Okay. Yeah, no, we're speaking kind of in the hypothetical for sure. Let me then jump to my list of questions. So first one I've got is that, so this judicial committee.
I'm sorry, Mr. Latham. Could we also hear from Mrs. Harlos? She wanted to answer your question as well.
Oh, sure.
Hi, Mr. Latham. I'm sure you're aware, and you can correct me because you're more knowledgeable if I'm incorrect. The statements in my amended complaint are the subject of litigation. They're more properly in the province of a court to determine if they are true or not. I'm not conceding that they're not, but like, for instance, under libel law, you can't be charged for libel for something that is in a pleading, because a pleading are assertions that are eventually going to be heard before triers of fact. I find it very interesting that although this lawsuit was allegedly not part of the charges and specifications, it seems to be coming up an awful lot. And I do want to make it clear to the Judicial Committee that a whistleblower email was sent to Mr. Hall back in July. So that was before an investigatory committee. So to the whole thing of retaliation being ridiculous is just not the case. This was brought to the attention of Mr. Hall, at least some of it, back in July. I don't want to answer more than you asked, though there are some other questions that JC members asked, such as about the form, that I would love to answer if a JC member wishes to ask me.
Okay, thank you.
One quick additional point is we're talking about an amendment of the policy manual. It's my understanding that there's a forthcoming JC appeal on that amendment, and that amendment may not pass muster anyway.
Right.
But I understand we're doing hypotheticals if that exists.
Yeah, we're going way far afield. I'll just, throw out for people's reference, there's a so-called litigation exception to libel, but there are exceptions to that. So have fun researching that. Okay, I want to get back to my initial first question.
Rob, can I just interrupt for a second? Just a housekeeping item.
Yes.
There are some people who do not have first last name on their screen names. There's Michael, Dana, JJF, Elpar, and Michael II. If you guys don't put your full names up there, you're going to be kicked out. And there's another one, Hector. Don't know who Hector is. So anyway,
Probably Hector Roos. He looks like Hector Roos, at least his avatar does.
I'm just looking at the list of names here. So if you don't have first and last name on there, be ready to do something else for the afternoon.
One of our own committee members has an initial M. All right. Okay. So first question. So this committee's, and this is to Dr. Moulton, this committee's December 4th decision vetoed the LNC's October 6th decisions and declared them null and void. So can the LNC's November 9th removal action of Ms. Harlos from the secretary position stand independently from the LNC's October 6th motions and temporary suspension? And if not, why not? And I'll say, I think we allowed Ms. McCardle to speak a little bit to that, but I don't think I'd heard from your side on that question. So go ahead if you would.
Yeah, I would say that it could not hold up. So I should mention that when I served on the Judicial Committee, we ruled that a trial was not required. And under that interpretation, they could just have a removal charge whenever. But since then, the delegates have spoken with a resolution saying a trial is required. And because a trial is required, and the trial has been nullified, everything that flowed from the trial has also been nullified.
All right.
Mr. Latham, may I ask, Ms. Harlos would like to answer your question as well. Would that be okay?
Yes.
Thank you, Mr. Latham. The only reason that the 2022 delegates were able to even raise the point of order is because they alleged a continuing breach of the bylaws. Otherwise, a point of order has to be raised at the time of the breach. And the continuing breach of the bylaws was that a trial was required due to the description of the terms of office of the LNC. So it wasn't an abundance of due caution or a policy manual requirement that required a trial. And if you look in Roberts, before a trial can happen, there has to be valid preferral of charges and the preparation time. Well, the charges were voided. So you cannot have a trial without valid charges. Since the charges were invalidated, there can be no trial. Now, certainly, as other people have said, though I think it would not be in the best interest of the party, they can certainly try again, but they would have to start the process all over again. But that trial is void because the charges were void. Roberts makes it very clear. You could only have a trial on preferral of charges. And I realize the recording's going to stop for a moment. Okay.
Recording stopped.
I'll wait till the recording resumes.
All right.
Recording in progress.
Hey, and as far as any assertion that the policy manual was suspended, this is why I require registration.
And we should. JC, make a note of this for the next hearing.
Well, I'll just even ask, do we feel like we need to take a break?
I thought there was some way, I thought everybody was going to be muted except for the JC members.
That's true, but when a question is asked of someone, they get a chance to answer. I'm not sure of the point of your question.
Oh, I thought that meant that the chair or the Zoom master was going to be controlling who is allowed to speak and who isn't allowed to speak. Maybe I had that wrong, but if there's some way we could do that, I would appreciate it, because I'm finding the interruptions distracting.
Well, that's
I'm not unmuting anybody, so.
Well, if I can add to that, Mr. Chairman, is there a way to configure this meeting to some webinar or other format where it's just JC members and we elevate people to, I guess, attendees or participants as we call on them? Or is that just too much?
I think there's some way to have people as panelists and certain people as, maybe it's too late to do that now. I don't know. I guess we can just move on. But I was just wondering if some way to just shut everybody off and then only turn on the committee members and maybe the litigants. I think that would be better. But if that's difficult, let's just move on. Put up with it.
If I may finish the answer, a rule protecting a certain minority, in this case, it's a minority of one, cannot be suspended and by anything that is you need pretty much unanimous consent or a unanimous vote for a rule that only protects one person. For example, the rule in the bylaws for the statement of principles of 7As is a bylaw in the nature of a rule of order, but it could not be suspended by 2/3. It would need to be at least by 1/8, by the same amount it would take to amend it. It's one of those weird peculiarities of Roberts. It's cited in my brief. I don't have the citation in front of me. So no, the LNC did not suspend anything in the policy manual, but because they couldn't, because it protects one person, the accused, but also it is required by our bylaws as determined by the 2022 convention.
Okay, so following up on that point, so is it your position that the party can never get rid of the trial requirement for any removal of an officer? Are we locked into that 2022 convention? I think let's start there.
They can by amending the bylaws.
Okay. All right. So, and I guess in fairness, then just want to, so the question really coming back to this, and I think I'll direct it to Mr. Jacobs, because I think this is again more of a parliamentary procedure question and just kind of restating it. So the question is, can the LNC's November 9th removal action of Ms. Harlos from the secretary position stand independently from the LNC's October 6th motions and temporary suspension action? And if so, why so?
Based on the bylaws, yes. Part of that is because the bylaws give a method for restoring somebody. Article 6(7), the Judicial Committee shall either affirm the National Committee suspension of an officer or order the reinstatement within 30 days of that hearing. To date, you haven't done that. You might do it today, but to date, you have not done that. You would have to do that in order to reinstate Ms. Harlos. If I can go with just a little something that came up, may I do a bit of follow-up on something?
Sure.
Yeah. In 2022, the bylaws
I appreciate the whack-a-mole efforts of our Zoom operator.
I don't want to interrupt, speak out of turn, but is it possible to go and put in a waiting room?
Yeah, I put that question, Mr. Chair. Maybe I'll revise my question. Is it possible to make a change here? I'm just getting silence from our host, as worthy as his efforts are here.
I can put them in the waiting room, yes. Problem is they're spamming in on other names, and I'm trying to get them out as fast as I can, so.
Point of information, Mr. Seebeck, I put in the comments how you can block this from going on. I gave you step-by-step instructions.
I do see that. If all the participants are willing to bear with us for a moment, I can try to make that adjustment.
Sounds worthwhile. He can't control himself. He keeps interrupting. Doesn't matter who he is.
One moment, folks. I'm gonna put in these suggestions that have been in the chat to see if we can fix this. So bear with, if the meeting will bear with me for a moment, we'll take care of it.
Okay, we'll stand down for a few minutes until we get things settled out.
Thank you, Mr. Chair.
You're welcome.
And only
recording while this is going on.
Recording stopped.
And only because I promised, the reference is 25, Roberts 25:2, subsection 7, that says suspension of the rules usually requires a 2/3 vote, but no rule protecting a minority of a particular size can be suspended in the face of a negative vote as large as
Ms. Harlos,
be
We're
protected.
currently not recording at the moment.
Oh,
and
I
I'm trying
know.
to
It wasn't meant to be part of the recording. I just meant to throw out that reference because I didn't. Yeah, so I was just saying there was a negative vote of more than one, so that there was no suspension of the rules, that would not have been permitted in that particular circumstance.
Can I ask if Mr. Jacobs is back in?
working on it.
Thank you.
Hopefully, Mr. Jacobs can hear this question, and it's a follow-up to his statement that a trial is not necessary based on the bylaws because the bylaws provide a method for restoring a removed officer. And my follow-up is just, is there some authority in our parliamentary authority for that claim?
It's a bit. Can you hear me?
I can hear you. Did you hear my question?
I think so, yes. But the problem was that was not my answer. I said that basically it would be necessary under the bylaws to go through a process for restoration of an officer that was suspended, and that you have not done that as of this point. And that bylaw is, let me just get it here. That bylaw is in Article 6.7. The Judicial Committee shall either affirm the National Committee suspension of the officer or order the officer's reinstatement within 30 days of the hearing. Basically haven't done either one of those things. So it's kind of in limbo. You didn't do that in your last decision.
Okay. I think that question, I guess I had in my mind this was related to the question of whether a trial is required or not required, but that was not in my question. As I see again, but just that question was
doing a follow-up statement. Would that be helpful?
Sure. Well, let's try.
Okay. I was doing a follow-up statement that dealt with whether or not the trial would be required, or whether or not it can be removed by a special rule. It can be removed by a special rule without question. Robert provides, and I can get you the citation for this, so just give me a second. Robert provides that special rules of order may be adopted to, here it is, it's special rules of order may be adopted that would change the disciplinary proceeding. It's footnote 10 for section, here it is, 6332. And I'll read the entire footnote, it's very short. The Assembly may vary from the procedures described here through the adoption of a special rule of order for disciplinary proceedings, either by previous notice and a 2/3 vote, or by a majority of the entire membership. In this particular case, that would be a majority of the entire membership of the LNC, or a 2/3 vote of the LNC. Would not be necessary to amend the bylaws. If you take a look at my filing in the first Harlos removal in 2021, when in fact, it was part of her case in chief, I said that, yeah, they could adopt a special rule to do this if they wanted to do it without the requirement for a trial.
Okay, thank you. And I'll indicate I have 6 questions. I made a joke to our committee that I could do this for an hour, and I was joking, but maybe now I'm not joking. Question number 2, and this is directed at Dr. Moulton on behalf of Ms. Harlos. So upon being directed by Ms. McCardle not to submit the nomination certificate for the party's presidential candidate to the Colorado Secretary of State's office. Was there anything from the party's membership? Was there any, I guess, restriction from the party on preventing Ms. Harlos from going on X, Twitter, YouTube, other platforms to report the situation before deciding that she was going to unilaterally send in that nomination certificate to the Colorado Secretary of State's office? And if you think you need me, Dr. Moulton, to restate that question, I can. I see I...
No, that's fine. So first of all, I should mention Ms. Harlos wanted to weigh in on your previous question, but first I will answer the question you just posed. So she followed the law. She followed her secretarial duties and Colorado law. And by the way, this is a good time to clarify something that was asked before by Mr. Montoni about that form, which it took him 1 minute to find. It took her 0 minutes to find that form because it was emailed to her. So she didn't have to hunt around for the form. That was the form that was provided to her. And it was important that the LNC is making much of a deadline, which I think they claim is September 6th or something like that, that was far in the future. The reality is the deadline that they were actually dealing with was the write-in deadline. Because by slow rolling filing, he might have been left not being able to get on the ballot and also not being able to be a write-in candidate. So that's the deadline he was dealing with, and that is detailed in the Dasbach amicus brief that was sent to you. So basically, when she did her job as secretary by filing that paperwork when it was requested by the Secretary of State's office, and I guess specifically you were asking, could she have talked about it publicly before filing it? She could have. I don't think she needs to. She doesn't need to tell people in advance that she's doing her job. And could you please hear from Ms. Harlos on this in the previous question as well?
Tell you what, let me give either Chair McCardle or the LNC a chance to weigh in on that same question. Just was there any, thing on the parties' end, such as a non-disclosure agreement or other directive saying don't discuss this, that would have prevented Ms. Harlos from saying, hey, the parties slow rolling this, and sorry, I just, Stefan and I think also Mr. Stratton, we're noticing that when any of us talk, we can hear it, I guess, if we're not muted. So I'll restate my question to Chair McCardle or whoever wants to answer on her behalf. Just was there any restriction coming from the party, again, either a non-disclosure agreement, some kind of policy that would have prevented Ms. Harlos from, once being aware of this perceived, kind of slow rolling of filing certificates of nomination, that she couldn't have gone public and say, hey, this is going on. Can you let the LNC know that, we oppose this strategy?
I don't think so. And when you say this strategy, you mean like wait and see? That was something
That's right.
That was discussed with the Reconciliation Committee. And I mean, she's sent various, emails expressing strong opinions about all sorts of things. She could have said something about that. She didn't, and her reply is attached and included in the IC committee. And also the Secretary of State of Colorado did not request anything from us. That's not true. And if it is true, then that was withheld from me, wrongfully so.
Okay, let's go to Ms. Harlos, because I know she wanted to weigh in on our prior question.
I think if you have further questions on that prior one, but on this, the Secretary of State actually did 2 requests. One was through the campaign, which was forwarded via email, which had the form attached to it, which was saved on my desktop. I never had to hunt for a form. That form was sent to us by the campaign. The chair was on that email, in which it was requested that we send it. I had a telephone conversation with the chair that asked us to hold off, or me to hold off, us meaning the party, until it was apparent that any reconciliation would be impossible. The minute Colorado Party puts out a press release and starts fundraising off of a different candidate, it's over. And then the campaign itself requested me to file the paperwork. But I had already talked to the Secretary of State. Just because I initiated the call with a question, the question was about what documents are required, because there was a checklist on the form. And I thought we had to submit everything at once, which is something that I had expressed multiple times to the chair. During that conversation on my question about the checklist, the Secretary of State, sua sponte, asked me for our form. They said they were waiting on it. Can we have it? So they did, in fact, request it. There's nothing in the requirements that says the Secretary of State has to call us. It was in the midst of a routine call that they specifically asked me for the form. And immediately after that, somebody I hadn't talked to in a year and a half from the campaign called me and asked me to submit the form.
Okay, thank you. And gosh, since I have you there, this kind of maybe leads into my next question. I can find it. So I want to say from your brief, sorry, that you are claiming that the Colorado write-in deadline creates an exigency, an emergency, requiring you to mislead the party chair and act unilaterally against the party chair's explicit instruction. And so my question is, do you know how many other states received nomination certificates from the party after that state's write-in deadline in the 2024 election cycle?
I have to object to the way that was characterized, because the instructions from the chair were that we would hold off up until the point that negotiations were obviously unsuccessful. And they were obviously unsuccessful once the Colorado Party puts out a fundraising press release that they're putting RFK Jr. on the ballot. It is the job of the secretary to make sure that the nomination forms go in. That is the job of a recording secretary. Recording officer, when you do not have a corresponding secretary, which we do not have in the party. When you do not have separate offices for corresponding, and I forget what the other type of secretary it is. The first duty in the bylaws of my position is to be the recording officer of the party, and that is to certify the official acts of the party, and also to answer the routine inquiries that of the party. Now, we delegate a lot of that stuff out, but if it doesn't get done, and Colorado had made it clear, very, very clear, they were never going to put Chase Oliver on the ballot. Bylaws 14.4, which puts the responsibility upon the entire LNC, each and every single member of it, to make sure to give full support to the candidates. If Colorado had some weird form where only the treasurer could sign, then it would have been the treasurer's responsibility. The campaign could only be on the ballot either as a Colorado Libertarian or as a write-in. And if you tried to drag out negotiations past that write-in deadline and they failed, they wouldn't be on the ballot at all, which would have been subverting the will of the delegates. But in the understanding that I had with the chair now, you know how communications can be. She may have thought it was different. I am not going to be calling Ms. McCardle types of names that I have been called here. It was my understanding that once negotiations had obviously failed, and there's nothing more obvious than a statewide press release fundraising off of putting RFK Jr. on the ballot. If we were to allow that to go forward, the party would be endorsing fundraising fraud, because he is not, in fact, the Libertarian Party candidate.
I would like
Okay.
to weigh in this very briefly, if I may, Mr. Latham.
And I want to hear from you too, but I think
Okay.
just while Ms. Harlos and I are kind of digging into this issue, I just wanted to see if she can, because I just had 2 questions based on what she said. So what's your source for this negotiations unsuccessful is the
It was a
trigger
phone
of
call.
no longer hold off. It was a phone call.
It was a
And
phone call, yes.
Because I just, my follow-up was, how did you come to that understanding? It was a phone call between you and Chair McCardle or anybody
Yes.
else?
No, me and Chair McCardle.
Was it just you two or any others on that phone call?
But we never had multiple people on a phone call that I can recall.
Okay.
I don't know how to conference people in. So, Angela might know how to, but I don't.
Okay, thank you. And then, but I did want to get back to my original question. We kind of went a little off track. Do you know how many states received nomination certificates from the party after that state's write-in deadline in the 2024 election cycle?
No,
Okay.
I don't. That was something that would be tracked by the ballot access committee if there was ever any kind of danger of that.
Okay, and I do
May I
see
respond?
Mr. Redpath on this, so it may be interesting to hear from him. Let's kick it to Dr. Moulton, and then, of course, I want to hear from
Yes,
the LNC on this.
So I can't get you a number on the. Oh, I'm sorry. I can't get you necessarily a number on your question, but I can tell you, having been involved in the party for 30 years now, that in my experience with ballot access in Pennsylvania, in Tennessee, and several other states, that you don't want to do last-minute fire drills. You want to get things in far before the deadline, if possible. And we, in fact, had a last-minute. We've had many last-minute fire drills in Pennsylvania, where we're scrambling the last week, as Ken knows. But in addition, in Tennessee, we had a last-minute fire drill this year, where the write-in deadline was very soon after the deadline to get on the ballot, and we did not get on the ballot in Tennessee. We had to scramble to get to the write-in deadline. I drove, and this is not an exaggeration, I drove 1,000 miles around Tennessee to collect elector signatures, last-minute fire drill to get us on the ballot, or not on the ballot, to get an option of a write-in. And we failed that due to a technicality. If we had had more time between those deadlines, I mean, really, we should have prepared that in advance, and that's somewhat on us. But it is really helpful to do these things in advance to the deadline. And if you put things up to the last minute, that's when problems happen. One other factual matter I want to correct that was highlighted in the LNC's brief. The LNC said there was no problem with RFK in actuality because RFK had got on by another means. But that is not preventing LPCO by putting someone else on the ballot. In fact, they talked about the approval voting candidate being their candidate instead of our presidential candidate. And it is not preventing no candidate from being on the ballot. And if you looked at the brief that was filed by the executive director of the LP Colorado, like an hour before this hearing, he asserted that Colorado has the right to file no candidate. Ms. McCardle has said that when she emailed to withdraw the electors, that did not actually affect the filing with the Secretary of State, but in fact it did, because all of this paperwork was necessary to be put on the ballot. If she withdrew, if she either were able to successfully withdraw the electors and another elector slate was not submitted, we would not have been on the ballot, or if this filing was not made in the first place, the certificate of nomination, if it was slow rolled to the point where we missed the deadline, then no one would be on the ballot. And that is not something we want. We want to be able to vote for our presidential candidate. Thank you.
Okay, and let's kick it over to the LNC. I presume that's Ms. McCardle who wants to, on this question of, do you know how many states received nomination certificates from the national party after that state's write-in deadline in the 2024 election cycle?
I do not know how many states received nomination certificates after the write-in deadline. We had Vermont and one other state that were a little bit late. When I say late, I'm just saying late according to my comfort levels.
Okay.
Yeah.
I don't know if, and I don't even know if we have the ability to hear from Mr. Redpath, or even if he wants to be heard from on this.
Regarding, well, he did not vote with us on it, so, you know, he may have a
Well,
different opinion.
it's the fact question
Mhm.
of write-in deadlines as opposed to nominated candidate deadlines. So,
Got it.
Mr. Latham, one more point on this. In previous election cycles, the LNC had a staff member who was specifically tasked with filing all these deadlines. This election cycle, we did not.
That's
And
not the
that felt-
case. And I'd like to finish if I was still being
Oh.
questioned.
sure, if we need to
Thank
go
you.
back to Dr. Moulton, go ahead.
Thank
Chairman.
you. Yeah, our executive director, Ms. Hannah Kennedy, did the job of sending things in. She sent things into state chairs. She worked with state chairs to make sure that they turned things in and that they would establish institutional memory for the first time. And if a state chair asked Ms. Kennedy to send it in directly to the SOS, she did, and that happened in at least a couple of states. Furthermore, Ms. Harlos told Ms. Yanuskavich to keep all of this from me. And she used her personal email address to hide her correspondence with the Secretary of State in Colorado so that I would not know. And so to say that we had an understanding and maybe I didn't understand, that's a gross mischaracterization. And her actions after the fact demonstrate that. And Ms. Yanuskavich could testify to that as well. And she also works closely with our staff and is aware that they were very on top of things.
Okay,
M-
thank
Mr.
you. And
Latham,
Dr. Moulton, you had a follow-up.
One brief point of clarification. I'm sorry if I misstated this. I'm not saying that there was no one on staff who was sending in certificates of nomination. In the past, the actual sending in was done by Robert Kraus when he was operations director, but we had a separate staff member who was Robert Johnson, who was tasked with keeping track of all the deadlines and knowing exactly what paperwork was required. And I apologize if I was wrong in that characterization. Maybe that is a task that was also taken on by the executive director. But what Ms. McCardle basically said was the executive director took over Robert Kraus's duty of sending in that paperwork, which is important, and I'm glad that happened. But it is also helpful to have someone who is tasked with knowing what all of the state deadlines are, what it exactly is required for each filing, and being on top of all those deadlines. Previously, that was Robert Johnson. My understanding is Robert Johnson was employed by the campaign this time because he was fired by staff, and the campaign tried to track these deadlines. If you check the brief by Mr. Dasbach, Mr. Dasbach makes the assertion that LPHQ was not as helpful as past campaigns with following these deadlines. So I'm relying on his statements. Thank you.
Okay, thank you. And then I'll just throw out, I guess, we'll have some time to study this. If anyone wants to throw an amicus our way, charting the write-in deadlines as opposed to the nominated candidate deadlines in all 50 states, that would be interesting, at least to me. All right. Fourth question. This is to the LNC. So Chair McCardle or Mr. Jacobs, if he's back and available. So what's the removal standard on November 9th? Is it the policy manual standard or is it the bylaws for cause standard, and why?
Let me pass that to Mr. Jacobs and also correct the record. Mr. Johnson was not fired. Not fired. He was a contractor who quit, and we had him do a little bit of work after the fact, even after he quit. I think it's important that we don't do that to staff. Mr. Jacobs, go ahead.
Okay, could you repeat the question, please?
Sure. So what is the removal standard on November 9th? So that November 9th LNC meeting, is it the policy manual standard we've been talking about? So the gross malfeasance, or is it the bylaws for cause standard, and why in either case?
I would believe it would be the bylaws for cause standard. That's my opinion in this matter because, no pun intended, I do not believe that the policy manual can modify a claim in the bylaws. They can
Can I just interrupt you there? Just to clarify,
Yes.
policy manual cannot modify a claim in the bylaws?
A clause in the bylaws.
A clause in the bylaws. Thank you.
A clause in the bylaws, yes. It can act when the bylaws are silent, but unfortunately the bylaws are not silent. That said, I'm of the opinion, looking at what you've tried to say is the gross malfeasance standard, that the charges did meet that gross malfeasance standard. So that has to be my opinion on that as well, and that is actually that the injuring the society is in essence a broader term, and then, or it was a term that completely would include gross malfeasance. I've given the indication of what I thought would be the gross malfeasance.
Okay, and over to Dr. Moulton. And I'll restate the question. Just what's the removal standard on November 9th? Is it the policy manual standard? Is it the bylaws forecast standard? And why?
It is gross malfeasance. Our bylaw 7.1 says that we are allowed to, the LNC is allowed to adopt rules of procedure. It adopted a rule of procedure, and that narrowed cause. On this point, I do want to mention that the LNC has made the argument that because their vote was so high that implicitly the policy manual is suspended. That really makes no sense. And it especially makes no sense because during the trial itself, we pointed out a policy manual violation, which was that they had a court reporter who was there to make a transcription of the trial for them. And by the way, for them, but not for us. So we did not have this transcription available to make our appeal. That's another big problem. This was all done in executive session. We pointed out the policy manual says that you are not allowed to record well in executive session. So they immediately went out of executive session and suspended that part of the policy manual and then went back into executive session, which they're certainly entitled to do. So they could have tried to suspend these policy manual provisions if they wanted to try to do so, but they didn't. They're trying to claim that they've been implicitly suspended, which is, of course, ridiculous. So I hope I've answered your original question. Ms. Harlos also would like to weigh in if that's okay, and I believe her microphone is currently muted.
Okay, if we can hear from Ms. Harlos.
Yes, and again, they couldn't suspend it in the face of a negative vote that was at least greater than the majority it was intended to protect, and the person it's to protect just one person, and more than one person voted against suspension. On the question of what standard applies, I do not know if he's here. I don't even know if he'd be willing to testify, but there was a parliamentary inquiry, I believe, submitted to you and then distributed to the rest of the Judicial Committee, where Richard Brown had answered that question in full and much better than I think any of us can do in a quick hearing like this. So I would refer the Judicial Committee to Mr. Brown's opinion.
Okay, and I appreciate you mentioning that because
I do see he's on video, by the way. So
yeah, I do see him here. So if we need to call on him, in fact, that really leads into my next question. This is question number 5. I guess I'm skipping over 4 because Mr. Tarnoff asked it. So charge 2 of the LNC's referral used the words, quote, disturbs the well-being, hampers in its work, unfit for office, end quote. And that appears to be from the party's parliamentary authority. And so talking about parliamentarian Mr. Brown's opinion on the applicability of the party's policy manual to the cause standard for removal. And I'll just even ask before I ask this question, is the LNC aware of that opinion by Mr. Brown dated December 6th of this year? And you're muted, Ms. McCardle. Now you're unmuted.
No, and we had retained a different parliamentarian for all of our trial proceedings.
Okay, so you're not aware of it. So this, may just be something that, if you want to follow up on with it. My question to you was going to be, whether you agree or disagree with Mr. Brown's opinion on what standard is applicable here.
Certainly, and you know, I could have Mr. Jacobs answer that, but Mr. Brown is not technically our party parliamentarian. He's been our convention parliamentarian for several years in a row, which we appreciate. But I think that's mostly the extent of it, outside of giving advice here and there.
Okay, and I feel like Mr. Jacobs did really touch on this in his prior answer to some extent as to which standard applies.
He's available.
Okay, he is, but I think people can read his opinion and, you know, factor that into their decision making. I'm going to actually jump to question number 6. This is another one for
Mr.
you want to weigh in on this?
Just real briefly. So Ronar 6324 says in part, if such particular charges are not defined, then you can use the Ronar charges. But we do define them, because we define them in our policy manual. So even Ronar makes allowances for them being defined elsewhere, and we do define them. Our bylaw 7.1 allows the LNC to adopt rules of order, and it has chosen to do so to have a definition of what cause would be.
Okay. I want to read through my question just to make sure. We maybe touched on this, so sorry if this is going over old ground. So some say that a subsequent change is an acknowledgement that the prior condition of whatever was changed was deficient in some way. And maybe I'll use the example, you fix a broken step, and that's an acknowledgement that the step was broken. So it was deficient in some way. So what meaning then should our Judicial Committee take from the LNC's replacement of the language in the policy manual, the gross malfeasance, last weekend at the Rhode Island meeting with the new language, which is, quote, any party officer or at-large member may be removed by motion and for any cause the National Committee deems potentially harmful to the party. So that's a long question. Just Chair McCardle, just asking you what meaning, if any, should our committee take from that policy manual change?
Yeah, I'll let Mr. Jacobs respond to that.
As indicated before, in 6332, that would change the process for removing someone. It removes the trial process, though a trial technically still could be held. I do want to clear up one point. RONR 6324 notes that if such particular offenses as are defined in the bylaws, that's parenthetical, are not defined and are not applicable, the emphasis on the word not applicable, a member may be charged with conduct tending to injure the good name of the organization, disturbing its well-being, or hampering it in its work, or misconduct in office. It's not only just if it is not specified in the bylaws, or if there's something else specified in the bylaws or in a rule. It is also if it if the other charge is not applicable. So that would be those would be the two cases where you would have being able to use that charge. That's in 6324.
I'm kind of hearing say maybe that's a catch-all term. So if it's not covered under gross misconduct or failure to perform duties, that other language would gather in other stuff.
Yes, but I want to make it clear that I think that this did rise to the level, at least what is in the report did rise to the level of gross misconduct. I will also note in your prior opinion, you indicated that that might be the case and that Ms. Harlos could be recharged on that.
All right. Okay, so going over to Dr. Moulton for Ms. Harlos. So to your pretext argument, is it the position of Ms. Harlos that the LNC suspension of her from the secretary position has no impact on the derivative lawsuit because the lawsuit predated the suspension, or I guess, and I'm looking at various timelines. I'm really not clear on, I guess people are arguing over what are important dates and what are important dates. And you just, you talked about this pretext thing, but you didn't give any dates. So I'm just wondering if you can help me out a little bit on, again, just is it Ms. Harlow's position that whenever the LNC suspended her, removed her, regardless of when that happened, that has no impact on the derivative lawsuit because the lawsuit predated this LNC action?
I'm going to mostly let Ms. Harlos answer this, but just to clarify, we maintain this is one of the main reasons that they are removing Harlos, that it's a pretext. They actually don't like the derivative lawsuit, and they're trying to remove her to prevent the derivative lawsuit from happening. And we would encourage you to ask the investigatory committee if they discussed the demand letter during their deliberations, and to ask the LNC whether during the October 6th hearing they talked about the derivative lawsuit, because that's important. What is supposed to happen in trial procedure is you are supposed to charge the actual charges and the actual specifications, and you're supposed to vote based on those charges and specifications. And we contend that they had other reasons not listed that were more important to them, that they didn't like Ms. Harlos, and also that they were somehow afraid of this derivative lawsuit and believed that removing her would somehow make the derivative lawsuit go away. But for the dates themselves, I leave that to Ms. Harlos.
And before Ms. Harlos jumps in, I just, on pretext, I want to put this out there. There are some who say that it doesn't really matter if there's a pretext that exists. As long as there is at least one valid reason underlying the action, it doesn't matter that there are also invalid reasons, let's say. So I just,
right.
I've been through this pretext discussion,
sure, and
professionally for decades. So.
Right, and if the LNC actually believed the reasons and they were valid reasons, then yeah, that might be a good argument. But there were no valid reasons to remove her in the first place. I'm going to let Ms. Harlos answer this.
Okay,
though.
We're talking about dates. Why do you think are important dates on?
Well, I think a couple things flow in, but let me answer your question. I might be off by a couple days. Please forgive me. Dates are not my strong point. On or around September 12th, I sent a demand letter to the LNC. It was me personally. On or about September 19th, my attorneys, who's Dr. Moulton's not involved in this, it's different attorneys, who are the same attorneys who were retained by Ms. Vest, sent a demand letter very similar to that sent by Ms. Vest, making it very obvious that it was a prelude to a coming derivative suit. The derivative suit was filed, I believe, on October 1st, 2024. So that's it for dates. Now, on the pretext thing, I do hope you indulge me because you did a little bit on it, where you said as long as there are valid reasons, it doesn't matter if there's a pretext. I would say, sometimes I think we get a bit too much into what might be true in a court of law rather than what might be true on a libertarian judicial committee. If I'm to actually defend myself, I need to know the actual charges. There cannot be, in fact, a pretext. And I'm just going to put this right out there. If the derivative case goes forward, there are several members of the LNC who are willing is probably the wrong word, but who will not perjure themselves if they are asked under oath whether or not that during the October 6th, well, there's at least one LNC member that during the October 6th, 2024 meeting, if it was not stated by the chair that this isn't an exact quote, but it will be close enough to the substance, that we have to remove her so that it removes her standing to continue with this derivative suit. Whether in fact it would indeed remove the standing, I leave that to the attorneys. It is my understanding it would not, but I leave that to the attorneys. I have no idea. And that is something that if the derivative suit proceeds, will come forward in depositions and the like, but that is not part of this case.
Okay, so then your answer there kind of led to another question for me. So when we're talking about pretext, we're talking about this derivative action, right? I mean, does that define the scope of it? Is there more there for pretext,
There's
or is
a
that
bit
it?
more there. The pretext thing is something that I know can be proven. I'm just telling, I'm not going to say how I know, but it can be proven.
Okay, but no, my question is the pretext the derivative action, or is it other stuff?
Oh, I said there were several things in there. My strong opposition in public to the JFC is another pretext. And
can you unpack that? What does that mean? You're opposed to the JC?
Oh, not JC, JFC, the Joint Fundraising Agreement.
Okay.
Oh, I'm sorry, Joint Fundraising Committee, excuse me. And the fact that I had left the Mises Caucus. But the number one thing is the derivative suit.
Okay.
The other things are very subjective. That is it's certainly my strong belief and feeling, but those can't be backed up with concrete proof. I am telling you that the issue of the derivative suit can be.
Okay, so it's coming back to your statement that pretext matters because a person needs to know what they're charged with, what they're needing to address in a removal proceeding or some other kind of disciplinary.
And the LNC needs to have clean hands.
Well, that's a separate issue, but let me try to focus. I mean, you may be correct on that piece as well, but so were you asked during the removal trial to address the issues of the derivative lawsuit or your opposition to the Joint Fundraising Committee or leaving the Mises Caucus?
No.
Okay. And then that's all I have, Mr. Chairman, although in fairness, I guess I want to offer the LNC an opportunity to speak to anything that I went over there with Ms. Harlos and Dr. Moulton. Anything? Maybe, oh, I see the chair's hand up and he is muted. He's muted and he can't speak. There he is.
I just wanted to make sure that I was unmuted. Thank you.
Okay.
I also had quite a bit to say in response to that. That was a lot.
Okay, go ahead.
Okay, we did not recommend removal or an investigative committee because of the lawsuit. And I believe this is covered pretty extensively in Mr. Malagon's amicus brief. The IC was voted into existence on August 25th at an in-person meeting. And they didn't adopt a report until September 29th. And I believe that was still before the lawsuit. So that timeline just literally doesn't add up. And that's not the case. And Ms. Harlos was excluded from executive session because she filed suit. And that's something that she also recommended we do with Ms. Beth Vest when she filed suit. And it's also obviously something, that we've discussed with legal counsel. And trying to bully us to break attorney-client privilege and saying that we've done something illegal, that's not okay because we haven't done anything illegal. It sounds, for what I'm understanding, and maybe Mr. Kinsella was trying to probe on this a little bit earlier, is that the JC has not all fully read the IC report, or there was some question as to whether you were able to look into it before you rendered a decision on the Phillies appeal. And so I think I am going to formally request that you revisit or overturn that hearing. And obviously what you do is within your purview, not mine. But if you have questions on the content of the IC report and why we drafted it and recommended it, please, by all means ask Mr. Malagon, because it's a gross mischaracterization to say that we removed her for filing a lawsuit when we've all submitted voluminous evidence of her sadism towards us, damaging behavior towards the party, its reputation, triangulation between various board members, you know, including myself and Ms. Yanuskavich, myself and Mr. Malagon. Like, she's the most destructive force that I think the parties have encountered in 10 years. You know, that's outside of litigation. And we do contend that there's gross malfeasance, and that's why we cannot work with her. But Mr. Malagon can answer any questions on the IC report as well, certainly outside the scope of litigation.
Okay, well, I'm not, those are outside of the scope of my questions, so I'll
Sure.
leave it there, Mr. Chair. Oh, I do see Ms. Harlos has her hand up, though. I don't know if is this in
Yeah.
reference to my line of questioning or?
It is, Mr. Latham.
Okay, go ahead.
I never made the claim that the investigatory committee was set up as a pretext. I had said that the pretext came into play afterwards. Once the demand letter was sent on September 19th, it was obvious that a suit would be forthcoming because of the past pattern with the same attorneys with the Vest case. But I had never said that prior to the setting up of the investigatory committee, though I do think my whistleblower email to Oliver Hall in July certainly hurried that along. But never said that was a pretext, but I do think that hurried that along. There's something that Mr. Jacobs had said in a brief in 2021, where you might say the LNC says such and such behavior is harmful to the party. Well, certainly if some of the allegations are that certain members of the LNC have been behaving in ways that are not in the best interest of the party or in untoward ways, they are obviously going to think it's destructive, and other members of the assembly will think that it's not. It is very much in the eye of the beholder. The insults that have been directed towards me that I have not reciprocated here, I think are certainly destructive to the party. So I'm going to break mold for a second here because I did not want to stoop to that level. If we want to talk about destructive forces, there was a whole batch release of files last year that is linked to in one of my briefs. If we want to talk about destructive forces in the party, I do not think the chair has really a place to stand. And in fact, I would think most people on the LNC doesn't have a place to stand. As I said in one of my responses, I am sure all of us could produce about 100 cringe messages about and from and to all kinds of people. I do think in general on the entire LNC, like Mr. Malagon had mentioned, that I did laugh at a joke that he had made at Miss Vest's expense last term. And you want to know what? I went to Miss Vest personally, even though she didn't know about it, and apologized to her for that. We have all engaged in some behavior that we probably would not be particularly proud of. But I do think it is just quite overwrought for the chair to make that accusation, really even about anyone in the party. I would not make that accusation even about her, even though we are at odds right now. I just find it completely inappropriate.
Thank you, Mr. Chair, and the committee for its indulgence. And I'll just even offer that we've been at this for a while. I don't know if we need to stand at ease for a bit, or people need to take a break, or we just want to plow forward.
I am amenable to either one. I would say, why don't we just plow forward, because this is like going on without objection. Let's just keep on going. Because I know my questions are not extensive. A lot of them have already been answered. Any objection to continuing?
No objection. Just want to give people that chance.
Hearing none. All right.
No objection.
All right. Thank you for your extensive questioning, Rob. You warned us and it was true. I'm going to start off with Dr. Moulton. In your presentation, you said that, and the exact words on your slide were, you voted not to seat her. Is that the way it was, or was it you did not vote to seat her? Either you voted not to seat her, or you did not vote to seat her. Which one was it?
There were two votes, I believe, and I think Ms. Harlos can address this better because she was actually at the meeting. Actually, I'll just let her answer this if it's okay with you.
There was one vote. Mr. Redpath, and I'm not going to have the exact language. I believe Ms. Cousin had the language in her appeal. Mr. Redpath voted it to return me to my seat as secretary, and he said we don't need to revisit recent history. It's because of the recent JC decision, and the LNC voted no.
Okay. So Chuck, that means that your slide saying voted not to seat her. I don't think that's quite accurate. Okay. That's okay.
I apologize if I I still think based on what she said that it's accurate, but I apologize if I conveyed the wrong impression. That, I mean, they voted on whether to seat her. Mr. Redpath asked to seat her, and they voted against it. So that was my understanding.
Okay. Thank you. Now, another thing in your presentation up front, at no point did you mention the fact that the secretary disobeyed a direct order. Why was that?
I would love to have mentioned that. You gave me 10 minutes. I could talk for I could literally talk for 2 hours about all these charges, and I would like to take this opportunity to go into much more detail on that. So thank you for asking the question.
Not too much, just generally speaking.
Sure. Yes. So the bylaw that's relevant, and let me find the bylaw, but the basic gist is the bylaw is a two-parter. It says that the secretary acts as recording secretary, and in addition that has a duty to obey directives from the chair. The question is, what happens when the two conflict? When the chair asks the secretary not to do her job as secretary, not to do her job as recording secretary, which is in fact what happened. So my contention is that the secretary has an obligation to obey legitimate instructions from the chair, but that was not a legitimate instruction. It asked her basically not to do her job as secretary. And if she had followed that directive, I mean, that would be a form of misfeasance, failing to do her duty as recording secretary. So that's the underlying issue.
Well, Chuck, there was still another 3 days before the write-in had to be done. So
I agree with you, but as I said before, last-minute fire drills are a bad idea.
I agree.
It's not just. And by the way, it's not just.
Hello.
Oh, go ahead. I'm sorry.
Yeah, thank you. You said she was told not to do her job. That wasn't the case. She was told to wait to do her job.
Waiting is not doing her job. Her job is to respond to general correspondence, and her job is also to sign certified copies of acts of the society. So when someone asks for a copy of a certified act of the society, which is the nomination, it's her job to give that to that person, in this case, the Colorado Secretary of State. And when you say that there were a few days before the deadline, keep in mind, this was not the only paperwork that needed to be filed. In addition, electors had to be filed. And I confess I'm not sure exactly what other paperwork, but as you know, in your experience in Pennsylvania, it's not just one form that needs to be filed, it's several.
I know.
So,
and Chuck, this is going wide of the point. You
Okay.
know, yeah, things are tight, scheduling's tight. The chair gave an order under the secretary shall perform such duties as is prescribed by the chair, and
Right.
duty was not performed.
Her duty as recording secretary was performed. The chair ordered her to slow walk submission of that paperwork. And as we've established, slow walking that paperwork in many ways is just as bad as not submitting it, because you can miss a deadline, and deadlines have been missed by slow walking in the past.
It didn't. So you're.
No, but you say it didn't happen. This is a counterfactual. Would it have happened? And
It's
we already.
hypothetical. It's hypothetical.
No.
So what I am saying is that there was a looming deadline. She tried to get things in advance of the deadline, knowing other paperwork needed to be submitted as well, such
Going
as the
against-
electors.
Going against orders.
Pardon?
Going against orders.
I mean,
she took-
this
she
is
took over-
this.
she
I'm
took
sorry.
over the
This
decision of the
is
chair.
well. This is another issue with what you're saying. That again, it has to be a legitimate instruction of the chair. The chair is not the emperor. So yes, the chair can get assistance from the other officers and members of the LNC, but the chair cannot order people to do anything she wants. So if the chair were to order the secretary to go get her laundry or her dry cleaning, I mean,
that's not the issue. None of these things are the issue.
It is the issue because it was an illegitimate instruction.
It was not. Why was it illegitimate? The thing was eventually going to get done.
Mr. Dasbach submitted an amicus brief on this issue, and he pointed out that the act of waiting was bad for the campaign. It hurt campaign fundraising, and it resulted in the campaign having to spend more time on this state that they would have liked to spend on other states.
I know. Okay, Chuck, we'll leave it at that because you're not addressing my question. The fact that
I believe I did. I'm sorry if I didn't answer it to. Maybe Ms. Harlos can answer it better. But I tried my best, so I apologize.
Well, thank you. Because I wasn't talking about what the fallout was or might be. I was just looking at it from just a Boolean black and white issue.
Would you like me to answer it all, Mr. Krawchuk?
Sure. And my dad's not here, by the way. Just call me Ken.
Okay, Ken. I think Dr. Moulton said it correctly. There is a primary duty, which is of recording officer. I think he misspoke as recording secretary, but recording officer, and other such duties. The other such duties is in addition. It cannot contradict the primary function, which is to sign certified acts of the society. I mean, there's a bunch of other things to do, but the ones that are in dispute, and to answer the general correspondence. There's nothing that could be any more general than a political party who has in its purpose statement to nominate presidential and vice presidential candidates. So I was doing my job. The secretary, the chair cannot. And I know there is a difference, and I am not going to call anyone a liar because sometimes wires get crossed. I also do not believe that I disobeyed a direct order. We had a discussion that once it became clear that Colorado was not going to submit its paperwork, that we would be moving forward. But then I might be giving ammo to you, but I want to give you the whole story. Then it was made clear to the campaign that we would send the signed paperwork, but not to the Secretary of State, but to the state chair only. The state chair had made it clear she was never going to send in paperwork for Chase Oliver. So then it becomes, where is the duty? So that's where it becomes illegitimate, because the LNC is required per bylaws 14.4 to honor the will of the delegates at convention. And that is a higher duty to get our candidate on the ballot, particularly in a state that costs us nothing. The chair cannot override our bylaws duty. She cannot override my duty as recording officer, and she certainly cannot override the will of the delegates. And talking about things getting lost, I had asked Colorado for some paperwork that you would think they would have. I asked them for our certificates of nomination all the way back to 2012. That's not really that far. I mean, because elections are every 4 years. They were only able to send me the one for Joe Jorgensen. So like, secretaries of state lose stuff. They don't always get stuff. You cannot wait until the last minute. And the other form that was being waited on that Dr. Moulton didn't know is they had the signed certificate from Mr. Tremont. They were still waiting for one from Mr. Oliver. And I have no idea where he was on the campaign trail or anything like that. You know, he doesn't live in Colorado. He couldn't just drive to the Secretary of State's office. So there was numerous other pieces of paperwork to get in, but so that the National Party did its job, we get ours in, and then it's up to other people to do their job.
Okay, thank you for the clarification. I have just one last question, didn't get answered yet. And this would be for both sides. Policy manual 101, 1.014 says, well, one of the reasons you can remove an officer is for failure to perform the duties of office. Now, this is another nitpicking here. When it says duties of office, does that, do you think that means multiple duties of office, one duty of office? I mean, do you have to do two things wrong before you can be removed from office, or is one sufficient? So
Are you asking me, Ken?
both sides. You
Well,
got it.
okay. I would think if a secretary forgot to do a set of minutes, or, well, I don't know, maybe they had some kind of problem, and you know, that wouldn't be sufficient. It's one of those things, I think you know it when you see it, but it does have to be a pattern. To put an exact number on it, like for me personally, like if we've gone on 3-4 months and you haven't seen minutes from the secretary, is certainly failure to perform duties of office. Missing one set isn't. Is missing two? I don't think so. But when you start getting into three, yeah, I think you start getting into that territory.
Yeah, but this is a different situation here because you're talking about filing papers to put somebody on the ballot for president. It's
Correct.
not missing something. So is one large duty missed sufficient to
It
trigger?
wasn't a duty missed, it was a duty fulfilled to honor the will of the delegates at convention. Now,
That's not my question, but go ahead.
let's say some opposite was true, where I got asked, hey, tomorrow you're going to send in that certificate of nomination, and then our candidate didn't get on the ballot. Would that be enough, that one duty? I would think that is arguable, because that
Okay.
is a big thing, as you say.
All right.
Getting
All right.
our candidate on the ballot is not the same thing.
Okay, I get the idea. Ms. McCartle, would you like to address the same question? One duty, multiple duties? Where's the line?
It can be one duty only one time. If our treasurer messed up our finances by $100,000 one time, it would be enough to remove him. It doesn't matter if it was, an accident. But there's also a duty of loyalty and duty of obedience to the LNC, to abide by the decisions and the will of the body. And that's also been broken multiple times over and over again. And that speaks to hampering the work of the body and the LNC. And I do believe that rises to gross malfeasance, as I have testified many times. Mr. Jacobs, do you have anything to add about duty versus duties?
No, but I would agree that one duty could be sufficient. It is going to be a judgment call, and the judgment in this case initially is with the LNC.
And we did decide that the one act was plenty. Although, I will repeat, Passim, that there have been multiple acts that raised this, that one was enough, but there were many others that added to our decision and continue to do so.
Okay, I guess that raises the question, can the Judicial Committee substitute their opinion of what constitutes gross malfeasance for yours?
I don't believe so. I believe that if the Judicial Committee is going to act with legislative intent, then they're exceeding their scope.
Okay, and Caryn Ann, you have something you want to weigh in on that?
There'd be no purpose of a Judicial Committee if it couldn't. Because obviously, if we're before the Judicial Committee, there's been a decision of the LNC that they've decided that such and such has happened. There would be no point of a Judicial Committee if they couldn't. They need to look at, and in fact, your authority in this particular case is much broader than in a member appeal. And a member appeal, they need to allege a specific bylaws violation. in an automatic appeal, such as a disaffiliation of an affiliate or removal of an at-large or an officer, you guys get to judge the totality of the circumstances in light of of how the whole thing came about. So I do think that is the whole purpose in a disaffiliation action and in a removal action, that you do have greater oversight.
Okay.
I'd like to weigh in if that's okay, briefly.
Yeah, but I think I got the gist of the what each side wants to do. I don't know that's necessary. We're running kind of late.
Okay.
All right, Chuck, tell you what, we'll give you 30 seconds.
Okay, I just wanted to point out that you ought to use the ordinary meaning of what gross malfeasance is. And I also want to point out legislative intent is clear because the meeting was recorded where this was passed. And Chair McCardle actually asked, what does gross malfeasance mean? And several examples were provided. We have those quotes available. I mean, at the time it was passed, it was clear what that meant.
Okay. All right, thank you. All right, that concludes my questions. So we'll move on now to Mr. Seebeck. You're on, sir.
All right. First of all, to everybody, I apologize for disruptions. We're doing the best we can with them. It's not easy keeping juggling everything at once. This first question, it can go to both sides. I want to make sure everybody's unmuted first. They are good. What does Article 14, Section 1 say in the bylaws?
Are you asking me, Mr. Seebeck?
I'm asking anybody.
Well, I do have the bylaws up. I don't have it memorized. I'm sorry if that's a sin. 14.1, nominations of candidates for president and vice president of the United States may be made only at the regular convention immediately preceding a presidential election.
Yes. So how could Colorado then violate that bylaw by trying to nominate a different candidate?
I would refer everyone to the opinion of Mr. Balch.
I would say that it can't, and it's even stronger than that. So you cited the bylaws. In addition, all 50 affiliates signed an affiliate agreement, and those affiliate agreements had clear language when they joined, saying that they would support the presidential candidate and not support other candidates. And I'm trying to find that in my presentation here so I can read it to you. Okay, and I can. We hereby certify that if recognized by the National Libertarian Party as an affiliate, we will not endorse or in any manner support any candidates running in opposition to the National Libertarian Party nominees for president and vice president of the United States. That is language that all 50 affiliates signed, including Colorado.
All right, next question then. So if Colorado was moving to put a candidate on the ballot that wasn't the nominee of the party at the convention, the same convention I might add, where they didn't vote for that candidate, I saw the tallies myself, then doesn't that open up Colorado affiliate to litigation problems because of doing the wrong thing? And further, wouldn't then Ms. Harlos filing the correct paperwork cut off the possibility of litigation? I'm having trouble understanding how her actions cause an exposing of litigation where it actually looks like it prevented it.
Would you like me to answer that? I did not get
Please.
a chance to actually make any comment on the first question.
Please.
We received 2 cease and desist letters from LPCO because of her actions. She sued Colorado. She said she did that in her personal capacity. And of course, Colorado said, no, the only reason she was able to do it is because she was secretary of the National Party. The judge questioned her on that as well. I was on many phone calls regarding potential litigation from Colorado. I had to sort out some awkward things with the Kennedy campaign as well. So that was the situation there regarding litigation. I don't dispute that Colorado was not supposed to put Kennedy on the ballot. And I don't consider that part of this JC appeal or anything having to do with Ms. Harlos's removal. So if you question us on it, that's fine. We can share our opinions, but that is not part of why Ms. Harlos was removed. It has nothing to do with whether or not LPCO was right or wrong putting Kennedy or attempting to put Kennedy on the ballot.
Okay, so the LPCO
Mr. Jacobs had something to add.
Okay.
Yes. I wanted to start out by saying that I am in complete agreement that Article 14.1 prevents somebody or some other agency other than the convention, except through the process outlined further in Article 14, from appointing a presidential or a vice presidential candidate. That was my advice, and I permitted to testify to this to the Colorado party when they first asked me about it, and that I declined to work for them on the matter before their Judicial Committee because I thought it was a violation of the national bylaws. That said, there is absolutely nothing in the national bylaws that says the secretary shall enforce this rule. That is where there is a bit of a problem. This rule can be enforced by the LNC. It technically could be enforced by interested parties through litigation. If the secretary wanted to see this rule enforced, she could have gone to the LNC and asked them to enforce the rule through disaffiliation. She also, in a private capacity, not as secretary and not using that, with presumably other people in the state of Colorado, possibly with the actual nominee, could have filed suit against the LPCO. She chose to do neither of those actions. Thank you.
Ms. Harlos.
Oh, thank you. Actually, Mr. Jacobs is incorrect. I actually did one of those actions. I filed suit in Colorado. But the fact is, I would appreciate not being interrupted. Thank you. And the write-in deadline was coming up, and the state chair made it clear they were not going to put the candidate on the ballot. The judge actually had said in the hearing, in the final hearing, because I kept stating over and over that this is, in fact, as a member of Colorado, that this was to keep them from doing certain things within Colorado that the National Party had no control over unless they chose to disaffiliate, to the point that the judge said, we get it. This is you as a member of Colorado. So I, in fact, did file suit with the state of Colorado to make sure that they would not try to disqualify the candidate.
All right, because see, the trouble I'm having here is very simple. The allegations in one of the charges, the first one, was that putting the Oliver Termat ticket on the ballot, properly so, in Colorado, opened up the state of Colorado, the National Committee to litigation. The chair said that that was a threat of litigation from LPCO. What I'm having trouble with is how Ms. Harlos doing what she's supposed to be doing is somehow that litigation threat by Colorado is somehow her fault when they're the ones in making the threats and instigating that activity. There's not a connection there, because there's not a doing of an item which would have put things at risk, except for the belief of LPCO to do that because they didn't bother to read their own bylaws regarding nominations. And I know very well what they say because I have to write the darn things. So I'm going to ask first Ms. McArdle, then Ms. Harlos to respond, and then Mr. Moulton. How is LPCO threatening litigation against the LNC? How is that not their fault versus Ms. Harlos? Hang on, unmute. Where are you? There you are.
You want me to answer that?
Thank you. I'll answer, and then I'll pass it to Mr. Jacobs. It's not about fault. If someone sues us and we have an opportunity to avoid getting sued, we take that opportunity because that's good leadership. That demonstrates wisdom and good judgment and diplomacy, and that's what was lacking in this entire thing, and I had to bend over backwards 2 or 3 times to try to sort all of this out. And, of course, ultimately we got sued anyway by Ms. Harlos. But yeah, it's not about whose fault it is. When you're in charge, you have to assume responsibility for everything. And instead we saw deflection of responsibility, basically just dumping an ugly situation, making it much uglier in my lap in an act of, selfish aggrandizement. And Mr. Jacobs, go ahead.
Okay. I'm sure all of you have heard of O.J. Simpson. He went to jail, but he went to jail for something very specifically. He went and broke into a place claiming to steal back his own stuff. It probably was his stuff. It was probably taken from him illegally. But he did it the wrong way. That is the same thing we are seeing here. It is something that was done the wrong way. And Ms. Harlos's actions after this have greatly compounded that.
All right. Ms.
I
Harlos, would you like
thought
to
you,
respond?
oh, yes. Any actions after this, if this means a trial, is irrelevant to this proceeding. I'll also note that I was not charged with failures to perform the duties of office, so I'd like for us to stick with the charges. The LPCO broke its own bylaws, was in the process of breaking Colorado state law, broke the R&R definition of what an affiliate is. And in fact, there were members in the state of Colorado who were getting ready to sue the LNC if the LNC didn't do something about it. So it seems in this situation that no matter what, and the campaign was seriously talking about filing suit against the LNC. So if we're talking about suits, we really have to talk about who's on the right and what the credible threat is. Like I can say that, I'm going to sue Ken because he's insisting that I call him Ken instead of Mr. Krawchuk, and I like calling people by their last names, and I'm traumatized by this. Well, that's obviously silly. Colorado threatening to sue because they broke the law is like you punching somebody and them saying, stop walking into my fist. So it was not a credible threat whatsoever.
Just to follow up real briefly, not only was it not a credible threat, but it's very weird to use the threat of a baseless lawsuit as justification for breaching fiduciary duty to follow bylaw 14 to give full support to our presidential candidate. This is something we see in government often, that the EPA will allow themselves to be sued and just concede the lawsuit and say, okay, you win, in order to get new rules passed that they like. It's pretty ridiculous. So our fiduciary duty, or the LNC's fiduciary duty, is what's most important here. And their duty was to fully support the presidential campaign.
All right. That's all my questions. Thank you.
All right. Thank you very much. And moving to our last JC member, consult my list here. That's Mr. Stratton. You are on, sir.
All right, thank you, Mr. Chair. I guess it's a curse, maybe in this case, a blessing that I'm last because almost all my questions have been covered. I did have a couple things. I still not convinced one way or the other that this is actually like a certified duty of the secretary to form it, especially since sign this form, since the chair can sign the form too. Can somebody on either side prove to me how it's not, or it absolutely is, the secretary's duty?
Sure. It's not in the bylaws, and I gave a directive not to do it yet. And staff has a history of doing it. That's all very clear.
And I would answer that. I need to look up here for a moment, but it is actually in my brief, and I'd refer you to the opinion of parliamentarian Sylvia Arrowwood that is as part of the exhibits. These duties can certainly be delegated out, but ultimately it falls upon the secretary. The reason why there are officers in a party is that there are different duties. And if you go to Roberts and look up recording officer, that's where you'll find it. And it is absolutely my duty. But as I also said, tangentially, that's just speaking in general as the recording officer. If Colorado had some kind of weird form in which only the treasurer could sign, it would become his duty because of bylaws 14. The chair had made it clear that the form would never be sent directly to the Secretary of State. It's in an email to Mr. Dasbach. She said, yes, this is totally a state matter. I'm working with it, and we are only sending them to state chairs. And the state chair of Colorado had made it perfectly clear she would never submit a nominating paperwork for Chase Oliver. So then it becomes my duty as someone who could sign it, knowing that it would never get turned in, no matter who signed it, if it was sent directly to the state chair. And the chair is the one who, in that particular instance, not trying to be insulting here, I'm trying to say this in the least insulting way possible, in saying that she would only send it to the state chair, who has made it clear she was not going to put Oliver on the ballot, the she being the state chair, there's too many she's here, was in breach of duty.
And I agree with everything Ms. Harlow said, but just to add on, the LNC's contention seems to be that well, there may be a duty of the secretary to sign these forms. There is no, and to respond to correspondence, there's no duty to file forms, that they see that as a different thing. Well, someone has to file forms. And what the chair was effectively asking for was for no one to file the forms, because the chair was wanted to slow walk the filing. And Ken, I see, is disagreeing with me. But when you bring things up to the very deadline, and perhaps even past the deadline, because we don't know when things actually were filed, number one, that's a problem. Number two, it can't be said that there is a duty to fill out the forms and then put them in a file cabinet. Then the forms are useless. Something has to be done with the forms. What the chair was essentially saying she would do is the equivalent of putting it in the file cabinet. She was going to send the form to someone who said they were not going to file it. She was going to send it to the state chair, and the state chair has said that she effectively that she would never file the form for Chase Oliver. So what's the difference between taking the form, signing it, and putting it in a file cabinet for no one to see, and sending it to someone who is not going to file it?
Mr. Stratton, if I may.
Yes, Ms. Cardo, go ahead.
The goalposts have shifted quite a bit. When this first became a topic of contention, the secretary instructed us all that it had been filed because the Secretary of State said whoever files it first is the one that they honor. And there was no discussion of a write-in deadline. I want to remind everybody that she did all of this mostly through her personal email. She made sure to share all of that with her FOIA requests. So she did hide it from us intentionally. And most of her duties she has delineated very meticulously in the policy manual. And she's expanded her role considerably. She did not do this in the past. She did not do this. Robert Kraus, our former operations director, did it. Hannah Kennedy, who is our interim executive director right now and our former operations director, she was taking care of all of it. There was never, and this is all very well documented in the investigative committee report, which I encourage you all to please read. There was never an instruction to never file it or never turn it in. In fact, I said very clearly in writing, not yet, hold off. And that implies, obviously, and we had a whole reconciliation committee discussing that if push came to shove, we would get it on. But there was no rush, because we had over 2 months, and I had persuaded LPCO not to put the Kennedy paperwork in, and that is true, because when she did submit it, lo and behold, there was no Kennedy paperwork. So my diplomacy skills were working very well. This just not her, it's not her duty. It's not, and it never was. And if I needed her to do it, I would reach out and ask her.
All right, thank you, Ms. McArdle. I have another question. So
Ms.
if,
Stratton, may I please respond respectfully?
briefly, please.
Okay. It is not in fact the case that this is not the secretary's job. There are in my exhibits numerous evidences that it has been the job of the secretary for probably 10 to 15 years. 2020 was a very strange year because everything was done by mail because it was COVID, but it ultimately falls upon the secretary. That is within the secretary's duty. And Chair McArdle did in fact make it clear that she would only send to the state chair, that we would never send something directly to the Secretary of State unless it was requested by the state chair. And Dr. Moulton's analogy was apt. It's the same as putting it in a drawer in which nothing could happen. But I would also raise the issue here is that even if you took all of the other side's assertions as true for the sake of argument, none of this is gross malfeasance. Our candidate was on the ballot. When you're doing things in the moment, they're not always perfect. And Ms. McArdle is incorrect that I was using my personal email to do national party business. I separate my two worlds. My emails that are in the FOIA request, which I'd be more than glad to send to the Judicial Committee, were when I was inquiring with the Secretary of State in my capacity as a Colorado member. It would have been extremely inappropriate for me to email the Secretary of State using my secretary email address when my inquiry was as a Colorado member. I keep those two worlds distinctly different. And I really don't know how that would be hiding things from anyone, because I had no idea to this moment that anyone was reading anyone else's emails potentially. That never would have entered my mind back then, but I'd be more than glad to send you the entire FOIA request, and you will see that each of the ones sent under my personal email were because they were personal requests that had nothing to do with the national party.
All right, Ms. McArdle, would you like to respond to that?
No, I think that sums it up. She used her personal email and just, makes the distinction that this was for me as a person, not me as a secretary, even though I did the other things that were related to it in the capacity as a secretary. It is what it is.
All right, so Ms. Harlos, so what you're saying is the secretary's duty, a lot of what you're relying on is because it precedents. It's been the secretaries have historically done it.
It's both that and the RO&R duties of the recording officer of the party.
All right, thank you.
Really briefly, Mr. Stratton, I do want to
Yes,
say
go ahead.
we have documentation since 2004 of secretaries doing this routinely. So this is not like a new thing.
All right, thank you, Mr. Moulton. I had another question from Ms. McArdle. So considering like the state law and our bylaws, is there a reason why, and all I saw was a screenshot, so I don't know the full context. I'd like to know more about this. You would ask to withdraw the electors from Colorado?
Yes. Yes. One of the things that was communicated to me from LPCO is that they believed at the time that the secretary had helped to submit false electors and that it was election fraud. And I did not want us getting sued for election fraud. So I called our attorney, and I don't mind telling everybody about this conversation I had with our attorney. And I said, we're in a really difficult spot because this is our candidate and we don't want to pull him off the ballot, even though it's now a mess. But if we were culpable in any way in committing election fraud, that's going to be a nightmare. I don't know what to do. what can I do? And he was like, well, if you think electors were submitted fraudulently, you should request to withdraw those, but not the certificate. And I was like, okay, I think the same thing. So that's exactly what I did. And when the Secretary of State said, no, we're not going to withdraw them, I didn't press the issue. At that point, it was just about doing our due diligence. I have made sure that we're not going to be, advocating for anything to be done illegally. If Secretary of State is like, what's done is done, then that's all that it needs. That's all I need to do.
Thank you,
I
Ms.
just
McArdle. Ms. Harlos,
want
would
to
you like
make
to?
it
Mr.
I had
Jacobs also
nothing
had
to
something to add.
I had nothing to
Yes.
do with the electors.
If I
Okay,
may,
okay. Hold on
there
one
is
second.
a filing with an opinion that was submitted to the LPCO related specifically to the electors. And I believe that Ms. Harlos might actually agree with this because there was something similar in the suit that she did file. The electors are supposed to be chosen under the bylaws by the LPCO convention. The electors that were submitted, with one exception, were not those that were chosen. That was the actual bone of contention at that point. Ms. Harlos did not submit them. It became very clear in looking at this that it was very unlikely, even without knowing who did submit them, that she was the person who did it. But this was still done improperly, and it was a violation of the bylaws. One of the people who was a legitimate elector that was chosen is a gentleman that she nominated. His name is Wayne Harlos. Thank you.
All right, Ms. Harlos.
Yeah, I'd like to add to that. Yes, the Colorado bylaws do mention in its convention rules, the nomination of electors. But here's where you come into state law versus bylaws. Unfortunately, the state exists, and under Colorado state law, the campaign, and I didn't know this until after the Colorado attorney said it, because again, I had nothing to do with the electors. The Colorado state law allows the campaign to submit electors as well. So if there was an issue with the bylaws, that is an issue with perhaps the campaign and LPCO, but nothing to do with the LNC or myself. And from what I understand from talking with people with the campaign and testimony in the Colorado case, they never represented themselves as having been chosen at convention. And while my husband was one of the legitimate ones, he isn't one of the ones that was on both lists. That is a gentleman named Sean Vadney. When my husband attempted to sign the acceptance of nomination, the executive director from LPCO physically put his hand on my husband's hand when he wrote in Chase Oliver up at the top and would not let him fill out the form. He physically prevented him from signing it, and then he was declared to have vacated his seat. He did not vacate his seat. He wanted to sign the form for the duly nominated candidates. When Sean Vadney indicated he would only sign a form for the duly nominated candidates, the board also declared his seat illegitimately vacated. So that issue gets very complex, but that is nothing that I am being charged with. That is an issue between the LPCO and potentially the campaign. National has nothing to do with electors, and I let the chair know immediately that I had nothing to do with the electors. Now, perhaps she didn't believe me, and that's fine if she didn't want to, but I did let her know immediately. I had nothing to do with the electors, didn't know anything about elector law. I find all of that, I know more about it now, but at the time I found all of that pretty confusing and knew that was not the job of the National Party. But the fact that the chair did not withdraw my certificate of nomination implies that there was an authority that I had to sign it. Because if there was clearly no authority and I was acting ultra vires in submitting it, she could have withdrawn it and just refiled it later in order to appease LPCO.
All right, thank you both. I have one last question. Actually, I think it was covered previously, so I will cede my time, Mr. Chair.
All right. Thank you very much for extensive questioning. I learned a lot and changed my opinion in a few places. Thank you.
I think Mr. Kinsella has his hand up, Mr. Chair.
Can I have a quick follow-up?
Oh, I was about to say that because according to our agenda, once we get through everybody, we can go through everybody again if there are any still open questions. Stefan, you're on.
Quick follow-up. This for Mr. Jacobs. If I understood Mrs. Harlos in my previous question right, her view is that absent a provision in the policy manual, the bylaws by themselves would not necessarily require a trial for removal or suspension of an officer. I want to know if you agree with that.
That wasn't my position.
No, I'm sorry, I meant Ms. McCardle. I misspoke.
Okay, thank you.
Okay, could you please restate that?
If
A little bit louder,
do you
I'm having problems hearing.
do you agree with Mrs. McCardle that if I'm getting your position right, Ms. McCardle, that absent a provision in the policy manual requiring a trial per Roberts or some kind of trial, if that wasn't in the policy manual, if we just had the bylaws with the cause removal for cause provision, I believe Mrs. McCardle said that it would be possible to remove an officer without a trial, and so a trial is not necessary. I want to know if you agree with that.
With the absence of any rules, I believe that a trial would be necessary. I do agree with the point of order that was raised in 2022 on the appeal. But if there is some varying rule as to the process in the policy manual, then that rule should be followed. Absent a rule, I believe that Robert, and when there's people that do disagree with me, but absent a rule, I believe that Robert would require a trial in this case. The way that the bylaws are worded elsewhere, they basically say they have. It's been involved. Robert makes two distinctions when the bylaws are absolutely silent on the process for removing somebody. If it says you will serve and until your successors are elected, you're required to have a trial. If it says or until your successors are elected, you can just remove the person by a motion to rescind. I believe that the way that the bylaws are worded, I would say it is an and until clause, and you would be requiring to have a trial. Other people, including Mr. Brown, have disagreed with me on this matter. But I believe that that is the correct case, and I'm also quite sure that that is what the convention said. However, this can be changed by a policy manual change. And I've maintained that since 2021 when this issue when I was with my first involvement with the issue.
Okay, thank you. And one follow-up. In the last appeal, the Phillies appeal, when the JC was deciding whether the trial charges and the trial procedure and the suspension pending trial were legitimate, how were we supposed to determine whether those decisions were legitimate if we didn't have access to the IC report or the trial, which was held in executive session? How are we supposed to evaluate a conclusion by the LNC if we are given no evidence?
It's difficult. I think it's really difficult, and I think that we have been hamstrung by this litigation and fear of it expounding. And we are at the point where, unfortunately, my position is, I would like you guys to please revisit the decision, and I can address that in my closing. Well, we've already been sued twice, and at the risk of sounding irresponsible, I guess go ahead and pile a third one on, because at this point, it feels that we are starting to encounter paralysis, and that there is no threshold, perhaps, where we can remove someone that we think is damaging our organization, but in some weird hypocritical, Uno reverse, they could use the courts to remove one of us. So
Okay,
we are gonna revisit that.
Okay, but given that, do you think that in the Phillies appeal, do you think the JC would have had the power to confirm your decision to suspend
Yes.
without having access to the report and the having seen the trial?
I mean, I do, but apparently you guys don't, which is why I think you should revisit it after reviewing the full IC report.
Okay.
I was under the impression that the IC report had been submitted.
So was I.
I certainly think that they could see it perhaps under seal, but
It's been shared, and I think that it is important. And at this point, it's been shared with the members as well.
With the general public as well.
Yes.
Go ahead, Ms. Harlos.
Okay, thank you, Mr. Kinsella. One thing I'd like to say about this IC report, and here's where there was a gross violation of due process, is that Roberts requires when there are accusations made, because now they're broadening this out to more than just the charges and specifications, that the accused be given every opportunity to have their side of the story heard. And probably about half of that report, they never even asked me about. Like, there's an accusation that I committed fraud and basically stole $430 from someone who's in chat who will say that's not true. I was never even questioned about it. The first I learned about it was when the IC report was given right before on that October 6th meeting. They did not question me about nearly anything. So my side of the story is not in this report. It's getting spread abroad, which could open the LNC to litigation. I'm not planning on that, because every time I even say anything like that, they claim it's a threat. It's not. I don't like litigation. The fact is, a derivative suit is a duty of a board member if they believe that fiduciary duties are being broken. And that is going to be for the court to decide. If Chair McCardle believes, or any other LNC member, I suppose, believes that they can't get rid of me any other way, they could do the same thing.
Okay,
They
thank
could-
you.
But
They could ask the court to do so.
Mr. Kinsella, can I briefly respond to your question?
Sure.
I think that it was very prejudicial to have the trial in executive session. The transcript was not available to us, but was available to them. Was not available to the Judicial Committee. You are supposed to be an appellate body. You're not supposed to have a trial de novo. So you need to see the trial transcript, and that was not available to you, nor to us when preparing our appeal. So that's pretty prejudicial to her defense. In addition, they weren't even allowed to do that. Like, it wasn't a good idea, but also they weren't allowed to do that. The bylaws say what are allowable reasons for executive session, and this just wasn't one of them. And we know this because I was on the bylaws committee when that bylaw was passed, and we discussed this exact situation where should a trial of an LNC member be in open session or executive session? Should we have an exception for a trial to allow that to be an executive session? And we said no. And that's the bylaw we have. And even if you disagree with the bylaw itself, there's also an LNC policy manual provision. The LNC policy manual says that when they go into executive session, they must specify the reason for going into it. They did not specify the reason for going into it. There are only 4 allowable reasons. They did not specify any of those reasons. And we don't think any of those reasons would have actually applied even if they had specified it.
I believe Ms. McCardle made the argument that the threat of litigation was one of the reasons, but in any case, I think that's in the pleadings already. I'm done. Thank you.
All right. Any other JC members have any additional questions?
I think I have a couple.
All right, go for it, sir.
A couple as well.
First of all, Ms. McCardle, there's something I just don't understand about this. Why wouldn't the national chair or secretary's jobs be to ship out the candidate's certification to all of the state SOSs within the hour after the results are known from the convention? I'll note that I assisted with that exact process about 20 years ago in one of our other ballot access filings. Why is it not? Why is there even a question of being a delay of any sort, much less more than a few hours?
Staff handles it. They did a good job handling it.
We-
They have
we-
handled it in the past.
When I was involved with it 20 years ago, that was the secretary I was helping,
Well, that
not
was-
the staff.
I mean, with all due respect, that was 20 years ago, and we inherited almost no institutional memory for Mr. Kraus. Nothing was written down. And our secretary told me before the convention that she felt a little bit panicked because she didn't know how to get them out. Those are things that happened. And, 20 years ago, there were a lot of things that were done differently, things that were done that are not done at all now, and vice versa.
Okay, my other question was, when you were talking before about your diplomacy with the LPCO, maybe I misheard, but I'd have to go to the recording to be sure. When you said when LPCO filed or went to file their paperwork for ballot access, I remember you saying, lo and behold, Kennedy was not in the filing. What is that accurate?
No, I think you misheard me. I said when Caryn Ann went to file the certificate of nomination, Kennedy's paperwork was not there. The LPCO did not ever put him on the ballot. They never submitted a certificate.
Okay, I see Caryn Ann has her hand up. Go ahead.
Yeah, and I can tell you a reason for that, which could be a different reason that Chair McCardle can disagree with, is because their vote on July 2nd had some technical deficiencies in it. And they, on the form, it says that, who's, I don't, that they have to check off that it was done by a vacancy committee, even though it had to be a vacancy committee of the National Party. So they redid that vote in August, and they knew a JC appeal was being filed about that. So they were not comfortable at that point filing the paperwork because they forgot to give notice in a newspaper of general circulation 15 days before nominating, because I alerted them to that. So no, it wasn't because in some great act of diplomacy. It was because they didn't cross their I's and T's when it came to notice. And they did immediately put in notice in the newspaper and have that vacancy committee meeting. I think it was August 6th, somewhere in the beginning of August. It is in the pleadings is probably the wrong word, filings in this case. I think nearly every argument here has been made. There have been some very nuanced questions, but the broader ones I think have been made in the main filings and the filings of the parliamentarians in this case. And I really encourage the JC to go through those primary ones of the LNC and myself and of the parliamentarians. Certainly the opinions of members are important as well, but they're not quite as granular as the questions that are being asked today.
Mr. Montoni, just to briefly respond to your question, what you said about what happened 20 years ago is consistent with everything we've seen. So 20 years ago, Bob Sullentrop was the secretary. We have a contemporaneous quote from him in the minutes of the meeting about him doing that procedure. We have quotes from the minutes of all secretaries since that is the norm.
It is not the norm. With all due respect, I inherited an absolute garbage heap, complete lack of administrative knowledge. There was nothing. I had to build over from massive sabotage. Our secretary had no idea how to get the certificates of nomination in. And it is no disrespect to her over that. I didn't either. So we built it from the ground up, and we actually have a store now of institutional memory, which did not exist before. And it really does, I think, it really shows a deep dysfunction we have in this party, that there are people on this call who said that they had 20 years worth of knowledge about how to do X, Y, and Z, and none of it was ever passed down to me. There's been no successorship, and that should not have any weight on any perceived fault of mine or the rest of the LNC. That is a fault of the party institutionally as a broader organization.
Ms. Harlos, are you answering my question again?
Um, well, I'm adding, I don't take it as disrespect from Chair McCardle, but I would nuance it a little bit. We did not have, for whatever reason, I'm not going to throw prior staff under the bus. We did not have a database of all the secretaries of state. That was my concern. When we left convention, we had 2 signed sets of certificates, and with the exception of 2 states, which I will readily admit, the reason we did not, so the general rule was that, and there's emails to prove this that were submitted, that staff was going to immediately send out the certificates of nomination to every single state and to every single state chair. And then we, as exceptions rolled in, like Colorado saying they had their own form, there were other states that had their own form, we would have plenty of time to handle them. If they were only going to be sent to the state chairs, we could have just photocopied them, and I would not have spent more of my own free time having a second set notarized. That was the understanding. What I was panicking on is that we did not have a database of all of the secretaries of state, and Ms. Kennedy started building that until the chair changed her mind afterwards and said, no, we're only sending to state chairs. Now, forget any dispute about Chase Oliver. Sending just to state chairs is a disaster in the making for anybody who's been in this party long enough. We have absent state chairs. We have state chairs that we don't know who they were, who they are. They haven't told us. We had that one instance in Montana, if you remember, when the state chair died, all of a sudden the Montana party fell apart because no one knew where the bylaws were, where the bank account was. They hadn't had a convention in 15 years. Sometimes, unfortunately, we have state chairs with problems and they're in rehab or their parents are sick or any number of things can happen. So you send them to both, but you always send them to the Secretary of State because they will write back immediately if there is a problem with the form. That could take a while because some states do require the signature of the state chair. And if we need that, sometimes it takes a while to track that person down.
One other brief point. The Chair McCardle said that a lot of institutional memory had been lost. The quotes that I have about the procedure come from the minutes, which are the official record of the Libertarian Party. Just because there's no employee manual that states you do this, this, and this, doesn't mean you can't go look at the minutes. Number 2, she's complained that no one provided her that information. There were plenty of people who could be asked. So Robert Johnson with the campaign, previous secretaries. I don't think that falls entirely on other people to figure out that the current officers don't know what they're doing. I think part of that falls on the current officers or current staff for not asking past staff members or not doing research. Again, I was never a secretary of the party. I found this by looking at the minutes.
And Mr. Chairman, I have a follow-up, although I know Mr. Tarnoff is ahead of me in our questioning order.
And I apologize, but I'll have to leave in 10 minutes, so I'll pass it to Mr. Malagon if you're still going.
All right. What can we? I guess not.
May I go ahead, Mr. Chairman?
Yeah, if nobody has any objections, absolutely go ahead.
All right.
I kind of have an objection.
Oh, we were waiting to hear from you, Blay. Go ahead. Sorry, I don't want to jump the line.
All right, I'll try to be quick. Ms. Harlos, I don't know if you answered this before. I didn't quite get the answer. Did you take your concern that the Colorado filing was being slow walked to oblivion? Did you take that to the Reconciliation Committee or the LNC?
It wasn't, I wasn't aware of the, whatchamacallit, the write-in deadline until July 8th. So at the time before then, my understanding was that the deadline was, I think, September 6th or September 8th. And in my own judgment as an officer, that was enough time if there was an issue to try to get those in. And then it became urgent when I learned about the write-in deadline. So with the conversation I had with the chair was that because the deadline was several months away, let's give time for Chase Oliver to meet with Colorado to see if they could come to some sort of agreement. Chase Oliver met with them on June 30th, 2024. The very next day, they nominated RFK Jr. And again, the whole thing about when it became apparent that reconciliation was not possible, then it was not, it was over. And that is exactly what happened.
Okay, I'm not sure if there was if my question was answered in there. So it sounds like you're saying that because things happened too fast, you didn't have time to take your concerns to the Reconciliation Committee or the LNC.
It's a little bit of both. It's a little bit of both, and there is going to be some judgment calls that I think every officer needs to make. The day after the Colorado board nominated RFK Jr., the former LPCO treasurer got in touch with me, and we weren't particular friends. We were Twitter friends. I'm Twitter friends with 34,000 people. Like I probably
I don't want to. I feel like I'm under time pressure because I know Ms. McCardle said she has to leave, so I'm just trying to get a quick answer. You did not take the concerns. You have a reason.
I did not. I had reasons for it and I did not. And the reasons for it were because of information, and it's in the pleadings. You can refer there where I have the screenshot of the conversation with Allison Spink.
Okay. It's my understanding that the plenary authority for the party is with the LNC, right? And that the LNC can delegate it. So my question is about the Reconciliation Committee. I guess this is for Ms. McCardle. Was the Reconciliation Committee created by the LNC specifically to deal with Colorado?
To deal with Colorado and any other states who are showing the same tendencies.
And were you a member of the Reconciliation Committee?
Yes, along with Kathy Anaskavich, Andrew Watkins, and Pat Ford, and Ms. Harlos.
And who chaired that committee?
I don't think we had a chair, but I appointed it, so I was like, chair.
Were you specifically granted authority by the I assume that the Reconciliation Committee was granted authority to deal with this issue by the LNC, right?
I appointed the committee. I have the authority to create ad hoc committees.
You appointed the committee for that purpose.
Yes.
Did the committee grant you the authority to act in the name of the Reconciliation Committee?
Yeah, we all divvied up states and made calls to different places.
So you're saying all the members of the Reconciliation Committee had authority to act in the name of the Reconciliation Committee?
Certainly, to reach out to states and see what they could do to convince them to get Chase Oliver on the ballot.
So that would include Ms. Harlos then?
Yes, but she resigned. She resigned from the committee prior to this.
Not true.
Okay. Different question. I know that there was a motion by Bill Redpath to reinstate Ms. Harlos, and it was voted down. But was there a point of order ever raised in the LNC meeting in Rhode Island that the trial or the suspension were out of order for lack of predicate charges having been, because the Phillies appeal dismissed the charges, eliminated the charges, null and void. So there were no charges Was there a point of order raised in the meeting that the trial or the suspension were out of order because there were no charges?
Mr. Keith Thompson raised a point of order. I don't remember exactly the wording. My ruling was that she would not be seated because when I asked clarifying questions of the JC regarding whether or not she was suspended or acting secretary, they did not give me an answer one way or the other, which told me that if they intended for her to be seated that weekend, they would tell me. They did not.
What would you have ruled now that you have the answer for the JC? Would that have changed?
No,
would
not
that
at
have
all. I
changed?
mean, we're still here having a JC hearing on her removal. I assume if her removal was completely void, we wouldn't be having this hearing. Or we would have opened it and said, by the way, officially, she is your secretary. This hearing is a formality, and we would have closed it.
Well, there's dispute about that. Some people, I think one way, or some people think the other. So,
Sure.
Okay, I think my last question here, Mr. Moulton, you were talking before about the changing the standard of conduct after the conduct has occurred. An ex post facto type due process issue. I was just wondering, do you have any cite to Roberts that would support that?
Roberts? Not off the top of my head, no.
I didn't hear
Richard, he asked whether there is a cite to Roberts of not being able to have basically ex post facto laws or ex post facto rules that apply to conduct before a provision is passed. As I said, I would analogize more to employment law. Maybe Richard Brown would have an answer to that. I do not have an answer to that off the top of my head, no.
I see. Okay, thank you. Yeah, we have a dispute here about whether we can bring in anything outside of Roberts, the bylaws, and the policy manual, and so it would be nice to have that within that four corners of those things. And I guess there would be the same question regarding the legitimacy of a motion's adoption where a member has been unduly prevented from voting on it. Is there anything in Roberts, and any of the parliamentary people are welcome to answer any of these questions, either for or against their positions.
Can you?
If I may.
Sure. Yes, JJ will go ahead.
Yeah. Okay. Yeah. First of all, if it did not affect the result, keeping somebody from voting would not make a difference. That was the same thing that happened with Ms. Harlos's removal and subsequent reinstatement due to the point of order in 2021, 2022. As to the ex post facto motion, there is no requirement in Roberts that would prevent it. There are examples in parliamentary bodies where this does occur, certainly in foreign parliamentary bodies. I believe that at one point an English king's ancestors were declared legitimate well after the fact, after they were dead. But there's also some case law in the United States. There's nothing in Robert. You might, however, see a peer-reviewed article in National Parliamentarian 2021, I believe, entitled Retroactivity. You should be able to Google that. It's online.
Okay, and that has to do with Roberts specifically?
That has to do with Roberts and parliamentary, it's Roberts specifically, but parliamentary procedure in general. Yeah.
Okay, and the last thing here, you said that if it doesn't affect the result, unduly preventing a member from participating would not affect the result if it wouldn't have affected the result. Do you have a cite for that in Roberts?
That one I do. Let's see. It's I'm trying to think here. Let's see. I think it's in section 23. Yeah, this deals with improper inclusion of votes, but it would be 23.8. The similar thing would imply that it would have to affect the result. There's also probably something back under the voting section. So
okay, I know I'm putting you on the spot here. If you can find me those sites, I would appreciate it, and send them to the JC. Okay.
I'll be happy to.
Thank you, and I'm gonna have to drop off, unfortunately. I apologize. I've advised Mr. Jonathan Jacobs to hang up and call back Mr. Malagon, who I'm gonna pass the representation to. Thank you, guys.
Okay, I'm done. I was wondering what Ms. Harlos had to say, if it's something relevant to what I was asking, but
Yeah, it was. I agree. There's no Roberts citation on that. So I think on that we rely upon libertarian principles. An example I have given.
what is that? You said that.
Yeah, I'm gonna give an example.
Or a member being prevented from voting affecting the result. Which is that?
Oh no, you had asked me. There was two parts there. I agree with that whole thing. He'll get you the proper citation that I'm sure will be correct. But you had also asked about ex post facto, and that's what I was going to deal with. And like the example I gave is, let's just say that in 2026, everyone's mad at Angela. I'm not saying that's going to happen. Let's just pretend that. And they pass a bylaws amendment that says for the 2022 through 2024 term only, there shall be no chairs that are blonde. Would that be legitimate? That because she didn't dye her hair brown, she couldn't look into the past? No, of course not. It wouldn't be. She was chair for that time, no matter how unhappy anybody might have been. There are certain libertarian principles that we should hold to, and that is you follow the rules or the rules at the time. I don't think that should even have to be really explicated very well. And I am aware of Mr. Jacobs' article. I'm actually planning on writing a rebuttal to it, and would note that that is an extreme minority view within the parliamentary community.
That's the retroactivity thing he asked us to
Yes.
Google?
Mm-hmm.
All right. Thank you.
All right, Blair, you finished?
I am. Yes. Thank you, Mr. Chair.
Thank you. Okay, Rob,
Okay.
back to you.
Thank you, Mr. Chairman. I'll just ask, since is Mr. Malagon basically on deck, and have Mr. Jacobs available by speakerphone?
Yes, I do. I have Mr. Jacobs here on speaker, and I can also speak to the chair wanted me to close with a couple minutes here, if now would be the appropriate time.
Okay, we're not there yet. I think we're back through another round of committee member questioning.
Correct.
And my question's this, I'll put it on the record, I put it in the chat, but there's been this discussion of an affiliate agreement. I don't know that I've ever actually laid eyes on one, and I would just request that if someone has a copy of it, to just send it to the Judicial Committee, especially Colorado. D. Frank Robinson's name was invoked, and I guess his claim that an affiliate is not obligated to nominate the National Convention, nominated candidate. And just, the question is, would an affiliate agreement change that? Would it bind an affiliate to nominate the party's convention nominated candidate? I don't want to put folks on the spot, but again, Dr. Moulton on behalf of Ms. Harlos, or Mr. Malagon on behalf of the LNC, or Mr. Jacobs, have any say on that?
If I may start. First of all, I do have a comment from Mr. Robinson, D. Frank Robinson, who has indicated that a state is not obliged to have to put somebody on the ballot. They cannot run another candidate against them, but they're not obliged to put that person on the ballot. Local bylaws or state bylaws might require it. The second question was, what was your second question?
No, I really think that's, okay. Is Mr. Jacobs' question?
If I may, just to piggyback off of Mr. Jacobs' answer, so California is a prime example of this. So if the national bylaws allow for a state to not put the elected candidate from convention on the ballot, but California's bylaws require that be the case regardless. So whatever happens at convention must take place in California. So that's one example.
Okay.
Mr. Latham, if I could share my screen, I could go over more of my PowerPoint on this issue if you like, and I can also send this to you. But
is that
this is what it would have benefited if the trial had not been in secret, and you could have seen this because I went through this in trial.
well? Can you just email us your slideshow PowerPoint, or
I
do you
can,
think you
if
need to show it?
I can certainly email it if you like.
Okay, maybe that's
just real briefly, on the issue of affiliate agreements, many of the affiliate agreements that were signed and filed at LPHQ were lost in a flood. Several of them survive, and all of the copies that survive are identical. Colorado was one of the first affiliates to sign this agreement. So there's records that they signed an agreement. We don't have Colorado's agreement specifically, but we have every reason to believe it was the same as all the others. And we have contemporaneous minutes from the LNC, which state that all affiliates signed the same agreement. So I hope that clarifies.
okay. Nope, it does. Thank you, Mr. Chairman. And just maybe I actually have to, sorry to interject with a point of parliamentary inquiry. I see that regional member Adam Heyman of Nevada is claiming that this committee has the authority to mandate the recusal of 2 of its members. So my parliamentary inquiry is, does this committee have the authority to, I guess, involuntarily recuse 2 of its members? I was not aware of that authority, but Mr. Heyman seems to be objecting to the propriety of what we're doing here because we are not exercising that authority.
No, I'm not aware of that because recusal is always a personal matter. I don't know if I could get a citation on that, we could discuss it, but I'm not aware of that.
I'll get you a citation.
If Mr. Jacobs could speak to that, he is ready to speak to that.
Yes. Basically, recusal, as was just indicated, is an involuntary matter. Robert recommends that there be will be recusal in cases of, quote, personal or pecuniary interests not in common with other members. I don't know of any case here where there would be a need for recusal. There might be. Somebody might be in a business arrangement somehow with somebody here, but I don't know of any. Even in that case, the recusal would still be voluntary. The person cannot be prevented from voting.
Okay.
Okay. Thank you, Mr. Jacobs, and Mr. Chair, I believe that's all I have.
Okay, and I would say as chair that I'm not going to do anything about recusal. If somebody wants to do it, it's up to them. All right, with that, hearing none, we're going to move on with the agenda, and we're now at the closing argument.
Chair, wait a second.
Oh, why, we got another one?
You were up next for other questioning.
Oh, no, I guess the question is, does anybody else in the Judicial Committee have any questions? I do not.
Mr. Chair, I have a couple.
Okay, here we go. What were
I put them in writing, but there was objection to that, so I'm going to put them straight out. Hold on one second. Let me grab the note. Mr. Chair, Ms. McArdle stated that what went on 20 years ago has no bearing on knowing what to do regarding filing forms in 2024. It was a lot harder to look up SOS information for 50 states in 1996 and 2000 when I was active at the national level than it was in 2024. Sit one volunteer down now in front of a computer for a couple of hours and they would have been able to find all of the needed SOS information. Why is institutional memory still being used as an excuse? Second part of my question is, again, institutional memory. Past staff members were fired. So if they had needed information, why were they fired before the or why were they not interviewed before the pink slips were sent? Thank you.
I can speak to some of that if I may, Mr. Chair.
Go for it.
So my understanding is that the staff that was let go was not particularly helpful, and the transition wasn't able to answer questions. I'll also say, as far as institutional knowledge is concerned, things changing within the past 20 years, Things change all the time, sometimes every election cycle, sometimes a couple, but things obviously are updated. And it's not as simple as a Google search. In California, we did cut it down to the wire because there was an absurd requirement that required that 50% of the state electors, no more, no less, be male, and the other 50 be female. There were also other requirements that they sign. This was not the case back in 2020, I don't believe, but that they signed some sort of pledge that they were going to vote for whatever party candidate they were signing on for. So things change all the time. And there are certain things that won't. I mean, our internal procedures don't, but there's a reason that this is up to, and California wouldn't take, quite frankly, anything from national. It had to come from the state chair. So this is something that it's not as simple as it seems. And the state never makes anything simple. I had to go on several back and forths with the SOS here in California, and it required several phone calls and several. That's a great question. It does say that online. I don't really know how to do that. Let me ask my superiors and let me call you back. Something that should have been turned in and finished in California 2 months prior literally went up to the weekend before it had to be submitted. So just to be clear on that, I can't speak to any other state. I don't know other states. Excuse me. I'm still under the weather here. But that's what I suspect. I don't want to speak for the chair directly, but that is my understanding of the staff portion of why that institutional knowledge wasn't there. They weren't particularly keen to being helpful for it, and it wasn't written down. It was part of their leverage, as I understand, as to why they should be kept on, because no one else can do what they do.
Mr. Chair,
Yes.
again, my question is, why is institutional memory an excuse? None of this has any relevance on the fact that you can sit down with a computer and find all of this information.
Okay, I'm sorry. Then I'm misunderstanding your question.
Okay, then I withdraw it. Never mind.
Okay.
Obviously, I'm not going to get an answer.
Well, I'll let Mr. Jacobs chime in then.
May I try to get an answer? It was something that I noticed. You were talking about going to the internet and looking for something. Just yesterday, I went to the LPCO, or excuse me, to the Secretary of State's website dealing with electors. I didn't look at the actual statute, but I looked at the FAQ. I looked at the FAQs. I couldn't find the statute, and they told me that electors for candidates must be elected at a party convention, which is just what the LNC bylaws say. Now, we've been told here today that no, that's not correct. I don't know which one is correct, but if I were relying on that, that's the one I would use. I'm relying just on a Google search. That's what I would use. That might not be correct. We do have these kind of problems out there, and this is just not me doing it on a regular basis. It's just happened to me looking at it a couple of days ago, or I think actually yesterday.
Mr. Chair, I have to respond to that because it's not like LPC or the Colorado Secretary of State's website is inaccessible. While we were speaking of the filing paperwork earlier, I looked it up. I just Googled for the form that presidential candidates have to file to be gotten on the ballot for the major and minor parties to do their nomination process. I found it in less than 10 seconds. So I don't understand why there would be such a contention about this. I even provided the link to the direct form in the chat window.
Mr. Montoni, also to respond more directly to your question, Robert Kraus has given testimony that contradicts what they say, and I guess it's a he said, she said situation. So you all can decide who to believe. But Robert Kraus's accounting of his separation with the Libertarian Party was that he wanted to retire. He wanted to serve out 20 years or whatever it was with the Libertarian Party, and that he wanted to give them a reasonable time to train his replacement, and that he found that the LNC and the executive director were uncooperative. So he then resigned without that notice. So he afforded them the opportunity and they didn't take it. And again, I'm not Mr. Kraus. This is a he said, she said situation.
I'm struggling to find the relevance to Mr. Montoni's question, which is, I guess, why I can't answer it. I don't really understand what this has to do with anything, institutional knowledge or not. If secretaries did this 20 years ago, assuming that that's correct, then it presumably we don't know if the chair directed the secretary to do this because we didn't have staff that could do it or staff needed assistance. I mean, anyone can Google things, sure, and that wasn't as prevalent 20 years ago. I'm just trying to find what the relevance is to Mr. Montoni's question. And that's why I'm struggling to answer it. I don't really know what bearing that has on any of this.
My question was, why is institutional memory being used as an excuse for not having the paperwork available at the convention within a couple of hours of the
paperwork was available
at convention? Excuse me?
The paperwork was available at convention. This Ms. Harlos and Chair McArdle worked to get all of the paperwork done. That was not the paperwork that was turned in. I don't understand the confusion here.
Yeah, I don't understand the confusion either. I know what happens on the convention floor. I was one of the tellers. I was deeply involved in all of it. If somebody had asked me to help look up SOSs and paperwork, I would have done it. In any case, let's just.
That was not the form that was turned in. So I mean, I just kind of got to the point.
Go ahead, Ms. Harlos.
All right, thank you. It was my understanding at convention, and I did an immediate follow-up email when I returned home from convention to Hannah Kennedy and the chair, that immediately the documents were going to be sent out to the secretaries of state. Hannah Kennedy responded, yep, I'm doing the research right now. And she shared with me, which I've shared with the Judicial Committee as an exhibit to my filing, where she started creating that database of all the Secretary of State emails. So I also do not understand why that's being used, because that was the agreement when we left convention, that Hannah would be sending these out to every state once she got back. And I did a follow-up email at that time, and it was confirmed. It was only later, when certain states started raising some noise that they weren't happy with the candidates, that all of a sudden that this changed. But this should not be a reason. This was the agreement when we left the convention floor.
All right, Mr. Chair, I like I said before, I can see that I'm not really going to get an answer on the institutional memory section, so I'm just going to let you move on.
See, this is why you should recuse yourself, Mr. Montoni. This very combative behavior that you have. I'm trying to answer your question. I'm trying to find out what the relevance is, and this is one of the reasons that I believe that you should recuse yourself. Mr. Heyman was correct, and I mean, I'll just point out that we've probably spent out of 2.5 hours. Sorry, Mr. Chair, go ahead.
Recusal issue has been settled, so let's not speak to it.
I will just say really quickly that we have been on this call for about over 3.5 hours, and about 10% has been relevant to the appeal. And a big part of that is because it seems that a good portion of the Judicial Committee members have not read the Investigatory Committee report that was submitted to the JC, then under seal until we got full approval from council when the Phillies appeal occurred that morning. And that's not on the website for LPDIA. We did release it after that, and it's Exhibit A in my amicus.
All right, let's hold off on accusations and things like that. Anybody else in the JC have any questions they wish to add? Hallelujah. All right, then we move to closing arguments. We go first to the appellant, 5 minutes.
And just before Dr. Moulton speaks, I'd like to say one sentence.
This is part of your 5 minutes.
I get that. The IC report did not question me on half of the things in there. To say to just go look at the IC report does not have my side of the story, and that is one of the due process violations. Dr. Moulton.
Is it possible for me to share, or that's not possible due to the?
It should be.
Oh.
Mike.
I don't seem to have the ability to share my screen.
And I hope this technical part isn't out of our 5 minutes.
No, it never is.
Thank you.
Yep.
Ken. I almost said Mr. Crotcher.
Thank you, my lady.
It says sharing is not turned on. I mean, I could go with
one moment.
Mike can turn that back on. Hang on.
Thank you. I appreciate it.
Try it now, Chuck.
Okay. All right. All right. So first thing I wanted to do is clarify what was asked for about the affiliate agreement. Here's a copy of the affiliate agreement. The yellow isn't in the affiliate agreement. I've highlighted the relevant language. And this is the affiliate agreement that all 50 affiliates signed back when they first signed up. It says, we hereby certify, if recognized by National LP, we will not endorse in any manner support any candidates running in opposition to the Libertarian Party's nominees for President and Vice President of the United States. This is an excerpt from a LNC meeting where it was reported that this was required by every affiliate. So he said, required a petition signed by 10 members, endorsed by the National Statement of Principles, and the stipulation that affiliates not endorse any candidates for president and vice president other than those elected to the National Convention. And again, many of those affiliate agreements have been lost, but all evidence is that all signed the same statement. This is the form that, this is excerpts of the form that Ms. Harlos filed. It clearly refers to the national chair and secretary, not to the state chair and secretary. And it is or, not and. And again, this was sent to her from the campaign, which was forwarded from the Secretary of State. So it took her 0 minutes to find this form. Okay, so I've titled this slide wrong, but Steve Dosbach pointed out LPHQ previously did a lot of ballot access logistics. This included not only sending the certificates of nomination as soon as possible, but also figuring out what was required and meeting those deadlines. The ball was dropped in 2024. Our contention is that Chair McCardle slow walked filing of the certificate of nomination in Colorado. This cost the campaign money and time, which is detailed in the Dosbach brief. So they were up against a write-in deadline, which was critical for the campaign. Ms. McCardle later tried to withdraw electors, and that would have resulted in a full filing not being available, which could potentially have taken our candidate off the ballot. We did not get a chance to get that much into executive session, but the trial was held in executive session, which is extremely prejudicial to the defense, and it's prejudicial to the Judicial Committee. As an appeals body, you would like to see a record of the trial. Bylaw 7.5 says all votes and actions have to be in open session. Executive session can only be used for these things: discussion of personnel matters, contractual negotiations, pending or potential litigation, or political strategy requiring confidentiality. At the time that this was passed, I was on the bylaws committee. The author of this said potential expulsion of an LNC member is something that's always been discussed and acted upon in open session. So I don't think that's a problem. I don't think potential expulsion or other discipline of an elected member should take place in executive session. That's the stuff delegates have a right to know about. So the policy manual also restricts the LNC even further. It says when they use one of the 4 exceptions, they have to state that. None of these reasons were stated when they entered executive session. So that violated the policy manual as well. There were other due process issues that, unfortunately, we didn't get to all of that. The problems with the investigatory committee, problems with the fair process. Ms. Harlos was not interviewed about all of the charges during the interview process. She was excluded from the October 6th meeting when the charges of the IC were adopted and put towards the trial. She was given inadequate time to prepare for the trial due to having COVID. There was defective notice of the charges sent to her. Access to her email was cut off before notice was received. The trial was held in executive session. Recording was not available to us, but a transcript was available to the LNC, which is an uneven playing field. Parliamentarian was conflicted. And when I say parliamentarian, I'm not talking the parliamentarian for the trial, but Mr. Jacobs, who was consulted in some matters as a witness, had conflicts. Personnel issues were cited as a reason for going into executive session, not when we went in, but after the fact, after it was already over. On Facebook, for example, and that was really a pretext because the personnel mentioned was Jonathan Jacobs because he was paid a fee. Thank you very much.
Thank you, Chuck. Okay, for the respondent, 5 minutes, ready, set, go.
Thank you, Mr. Chair. I will speak first and then pass it off to Mr. Jacobs. I would just implore the JC to read the investigatory committee in full. Most of the questions that were asked here today are detailed, are laid out in detail in the report, particularly the reconciliation committee on page 10, Ms. Harlos's understanding. That was a very interesting find for the investigatory committee. While we're on that topic, you'll notice that the interview from Ms. Harlos, the recorded portion anyway, was just under 3 hours. That was just the recorded portion. Ms. Harlos opened up with a 45-minute opening statement. She was uninterrupted throughout the entire interview, and we actually were willing to keep going. I told the investigatory committee to prepare for a long one and gird their loins. They were ready to continue to go. Ms. Harlos, had very verbose answers to all of our questions that we were able to ask at that time. She was the one that said this was going on longer than she thought it would go, and so we eventually cut the interview. But I'm very familiar with the investigatory committee process. I've been on one prior to this with Mr. Duque on the LNC. I've been on one here or overseen one here in California, and I'll say that I've never known that the person or the subject of investigation or any person being interviewed gets to determine what questions are asked of them. That just seems a bit absurd to me. So we did cover all of that, and I would again just implore the Judicial Committee to read the investigatory committee report in full. I am always available for questions. It is very detailed. It was very thorough. It was about 200 plus man hours, myself, including me, Mr. McGee, the rest, Mr. Ford, Mr. Nikela, and Mr. Nana. So please do read that. I'll pass the rest off to Mr. Jacobs.
Thank you. I would note a few things. First of all, as noted previously, the executive session was necessary, not just for personnel matters, but for legal reasons. That's been handled, I think, repeatedly here. Further, the acts were all open, the actions were all taken in open session. They would have been fully, anybody could go and see them. Ms. Harlos was excluded from a committee meeting, effectively, not from the adoption of the charges. I believe that it was determined that there was a reading of the charges, but not the adoption of them. She had the charges and could have read them herself, but they were being read orally. As for conflicts, none. I think that the big thing about asking her how sick she was at this time was that on the 6th, she claimed to be very sick so that she couldn't do anything and couldn't help with her defense. But yet on the 7th, she mailed out a very lengthy complaint against me. I think that tells you how unfunctional or functional she was.
And really quickly, Mr. Jacobs, sorry to cut you off. I just do want to make it clear before the 5 minutes are up that the LNC is requesting that we want the JC to overturn the Phillies decision in its entirety, as was mentioned by the chair during the portion of this. But go on, Mr. Jacobs.
Or to vacate it.
Or to vacate it.
Yeah, and I will also remind you that the burden of proof on this thing is on Ms. Harlos. I think that is, oh, now there was one other little thing that she's mentioned here. Going into executive session. You don't have going into executive session is a matter for the body, the majority. It's not up to an individual member to say, oh, I want to go into executive session, or I don't want to have it taped. It's up to the majority of the room. If there is a rule relating to whether or not it will be taped or not, that rule is suspendable. It's not a rule protecting the basic right of an individual, of everybody. That is it for me. I'll pass it back to Mr. Malagon.
I will also just add that the LNC members submitted very important amicus briefs this morning. I would encourage the Judicial Committee to come over them. They are extensive. They cover everything in detail and even further detail than the IC report that references the IC committee report in its entirety. So I would strongly recommend, especially that of Chair McArdle, Ms. Yanuskavich, Mr. Watkins, Mr. Chatterton, that all of those be read thoroughly. And if there are any follow-up questions, we're always available for that. Thank you.
All right. According to our agenda, the JC has a chance to follow up with any questions related to the closing statements. Are there any questions?
Yeah, I have one question.
I'm not surprised.
What what basis would we overturn the Phillies report? What would the reason be for the Phillies' opinion? What would the reason for that be?
I'll pass that off to Mr. Jacobs.
Sure. One of the reasons could be, and there are many of them, is that it is moot, because what you did in that decision was effectively rule out of order or rule void a series of questions that had already been completed. You didn't basically do anything with that decision. That would be one of the grounds. Even if you would then go about and saying, no, you had to use that standard again, you could still get rid of that particular report. A second thing is, if you're claiming that that did remove Ms. Harlos, is that you would be in violation of the bylaws, because they require you to use a specific, there is a specific requirement that you actually say you are going to reinstate the person. It would be, that would be, I will admit that would be a possibility. I would not be thrilled with you vacating that and then finding her not guilty again, but that would be an option. I think it would be a lot cleaner. I think it would end a lot of the confusion that we have seen as to whether or not she was suspended or she wasn't suspended. I had taken a look at your letter, or response to her letter, excuse me, and looking at that, from what I could tell, she was not suspended, or she was suspended at that point. You did not reverse her suspension. Maybe that wasn't your intent, but I think doing this would make this a lot cleaner and make it basically a lot easier to deal with in the future, one way or the other. Does that make any sense?
Well, not really, because the Phillies appeal was under the bylaws, and all we had authority to do is overturn or veto decisions of the LNC. So there were 8 decisions of the LNC, and we vetoed them. We did not have authority to reinstate Ms. Harlos or declare her suspension invalid or rule on any other LNC decision other than those that were brought up in the appeal. So I don't understand how, but I guess that's your answer, and
I know I can add a little.
And that's it. Thank you.
It was made during the hearing, but the idea is that these motions were no longer in effect. You can generally raise a point of order or render a motion that is void that is in effect. You can rescind a motion that is in effect. But once the motion has been completely carried out, you can no longer render it void. You can no longer, basically there's nothing there to void. That was one of the problems that I saw with the decision. That it does create a great deal of ambiguity, and that this would at least end that ambiguity.
Okay, I'm done. I don't know if Ms. Harlos wants to add something, but I'm done, Mr. Chair.
Thank you. Ms. Harlos, please keep it short. You are the last speaker.
Oh, okay. I would just say that the JC said what it said. Its holding is very clear. The motions were still in effect as the foundation for a later trial. And to say that the fact that you're having it today means that it didn't mean that, again, could be the subject of the future Kazan appeal that you guys have, that you're on a leave of absence for until January 4th. But they were the basis for a trial whose effect is still, in fact, continuing. This is them trying to get a second bite at the apple when you guys have already, in fact, decided, and you based it upon what was happening then. If you feel you need to do something, I think the time to do that is in the Kazan appeal, where it talks about the implications of that decision, that's where any clarifications would be made. You have a pending appeal that you're not sending out, I guess, until after January 4th, that will deal with those issues, and that's the proper place to do it.
All right. With that, I believe that we're at the end of our agenda. That concludes our hearing. Thank you all for coming. Like I said, I learned a few things here. I got a few thoughts changed around. It's very worthwhile. Thank you all. Have happy holidays, and we'll see you in January.